everyone. Welcome to our second day of the spring oral argument session here in Pittsburgh. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and we were formally established as the Pennsylvania Supreme Court pursuant to the Judiciary Act of 1722. In 2022, we celebrated our 300th anniversary in Philadelphia. We are very proud of our rich history, and it's truly an honor to sit and work in three majestic courtrooms in Philadelphia, Harrisburg, and Pittsburgh. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent, and please introduce your co-counsel to the court. The justices are familiar with the cases, so I ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for any particular issues they may choose. Please remember that in this court we do not permit rebuttal. So if you ask, we will say no. In cases in which there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues that we wish to explore further. While there's no set time limit for oral argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time I will ask that you conclude your argument. Mr. Minner, please call the first case.
MacMiles, LLC versus Erie Insurance Exchange and Univ CNA Valley Ford Insurance Company. Representing MacMiles, LLC, Mr. Scott Cooper. Representing Erie Insurance Company, Mr. Frederick Santorelli. Representing CNA and Valley Ford Insurance Company, Mr. Anna Chemigan. Representing Dr. Ungarean, Mr. John Goodrich.
In these cases, which we have consolidated for purposes of oral argument, we consider whether a provision of a commercial business insurance policy which provides coverage for loss of business income from physical loss or damage to business property covers business owners for the income they lost while their establishments were closed due to Governor Wolf's emergency closure orders issued to stop the spread of the COVID-19 pandemic in 2020. In MacMiles versus Erie Insurance Exchange, the Superior Court, in an en banc decision, determined there was not coverage, while in Ungarean versus CNA, the same en banc Superior Court panel found that there was coverage. Please proceed.
May it please the Court, Madam Chief Justice, members of the Court, Scott Cooper on behalf of the appellants, in this case MacMiles, with my co-counsel Jack Goodrich and Lauren Nichols. This case, I think, starts in important what the late Chief Justice Barrett would always say: you get what you pay for. And the law of this Commonwealth and the law of contracts is when there is an ambiguity, you find in favor of the insured, which is exactly in this case. In this case, there is an ambiguity, which we'll get into and submit. Obviously, the insurance company is interpreting it one way, that they don't pay, which is usually how in the cases I handle, why I'm fighting it. In our case, if I was to tell you that you have a business like MacMiles that buys a business policy that pays for an all-risk policy, or in this case, an ultra-risk policy, pays an extra premium for business interruption that doesn't have to be purchased, that there's a natural disaster that this court in DeVito found deprived loss of property and personal injury that was forced to be closed because of the natural disaster, that the policy does not have any definition of physical loss of or damage to, there's not an exclusion for virus, which 80% of all policies throughout the United States have, and in Pennsylvania, so they could have protected themselves from this. what would the everyday person think? That they have coverage for the physical loss of damage to being able to go to the premises.
Why wouldn't they have had the word use in there? It would have been a simple matter to say direct loss of use of the premises or direct physical loss of the use of the premises. How do you get the word use into there? Direct physical loss.
Well, Justice Watt, that is that's our interpretation because they didn't put it in. If they would have they put physical loss up. And the one case I think which is important that actually in the MacMiles and the briefs they want this court to look at, which I actually would submit supports our position, is this Cleveland case from 1958, which someone once told me don't rely on a case from 1958 in 2024, but in this case, if they're going to rely on it, we can. That policy said destruction or damage to. In this case, and then over time, for somehow physical loss of came into being through some ISO form in the 1970s. And that policy said destruction or property. In this case, if the insurance company, and if we were to prevail, I would tell the insurance companies, this is how you could change your policy and not get into this problem, other than putting.
Follow up, Mr. Cooper, on that. So, I follow your argument. If you're correct that an order from the government that suspended dine-in during the COVID is covered under this direct physical loss, then what if the government ordered, presumably by statute, that bars couldn't serve alcohol until 2 a.m. anymore? They had to stop serving alcohol at midnight. Would you have a claim for direct physical loss? Isn't that the same kind of a claim as this?
Not really, Justice Weck, because in that situation, it would not be enclosed because of a natural disaster. And in this case, it was an unusual pandemic that the companies actually could have anticipated, because in the record, there is the note that the companies added that virus exclusion on the ISO forms after SARS in 2005. So this was anticipated, that something could happen, which is why they put the virus exclusion. So when the companies are saying this is going to be the end of the world, it's not, because 80% of all policies had exclusions. If the bar is forced to be closed at 2 a.m., they would not have a claim necessarily unless there was, like, say, a riot, or like the Detroit riots or something, or in Philadelphia when they had the closures. If I remember right, there were like people in the streets or something. Those were closed, but they would then be entitled to it. But if the governor just decided, hey, I don't like businesses being open past 1 a.m., they probably would not have, unless it was within the natural disaster declaration, which was only in this case for 90 days.
Mr. Cooper, could you clarify something for me? Could the business owners have purchased policies from the insurers that specifically said it would cover loss of use? Could they have done that, and would that have cost them more money?
There's nothing I've seen where they could buy a specific loss of use policy per se. The only cases I've ever seen where actually people were covered for this was people had purchased Wimbledon and the British Open actually had pandemic policies, and they were covered. That's why they didn't have it those years. But as far as a loss of use for the premises, there's none that I've seen where you could go and buy a loss of use policy for this situation. The only case I ever saw was in Texas, Harris County. There was a theater, I think, where they tried to make this argument, and the jury found, actually, after a issue of fact, in favor of, for $48 million, in favor of whoever the plaintiff was.
Well, in like manner, could the business owners have negotiated an additional provision into their policies for an additional price that covered loss of use, or has that never come up?
It's almost like trying to negotiate into an Erie policy, and this may bring up a bad case for me, a regular use exclusion to prohibit it. It would almost be like the same. Well, you know what? I don't want that exclusion. I actually tried to do that several years ago to Amica. When I had a provision added, I crossed it out, sent it back, certified mail, and said, I do not accept this.
Did you initial it, Scott?
Yes, and I sent it certified. And I had the green card, and then the general counsel called me and said, you can't do this. I said, I can, you just don't have to accept it. And he said, well, we will cancel you if not. And that's exactly what would happen here. The businesses had no ability to protect themselves in this situation. They had to close down for the period of time. And I think the most instructive thing to this court is that this court in Madam Justice Donahue and DeVito found that this was a natural disaster or other catastrophe.
Mr. Cooper, I want to understand, go back to your question, your answer to Justice Wecht. So you interpret physical loss, we're not talking about damage, right? You're focusing on physical loss. You interpret physical loss as it's a physical loss arising from a natural disaster, so other physical losses of use are not covered.
Physical loss of use of the premises.
Right, but
as a result of a natural disaster.
is that your definition of physical loss is loss of use as a result of a natural disaster?
No, just loss of being able to use the premises.
Well, that's why your response to Justice Wecht is curious, because you're then qualifying which physical losses of use would be covered and which ones wouldn't. And I'm asking what your textual basis for distinguishing between physical loss, certain physical losses of uses are covered, but other physical losses of uses are not.
Well, it would be necessarily, in this case it was a disaster, but let's say hypothetically you had a hotel that had bed bugs and there was one floor.
Well, that'd be physical damage. There's actually bed bugs there. There's no evidence in the record that the COVID virus was actually on the properties that you were denied use. I guess I want to go back to Justice Wecht's question, though, is what is your textual basis for saying physical loss of use because of a government order that says you can't access your property due to rampant alcoholism, and we're going to close the bars, is not a covered physical loss of use, but a physical loss of use that is the result of a natural disaster is a covered physical loss of use?
Well, in this case, that was what forced the closures. I think it really depends in the context of what your claim for physical loss of use. You could make an argument, and that's, in this case, that's why there's such an ambiguity, that it could be natural disaster. It could be something else.
Why is it ambiguous? I mean, because when the carrier wanted to use the word use, they knew how to do it, and I'm sure your client saw it. It's in the ordinance or law exclusion, which says the policy does not cover losses resulting from the enforcement of any law, quote, regulating the construction, use, or repair, unquote, of the property. So, if I understand your argument, you're saying that the business suffered somehow a covered physical loss because the law deprived it of the use of its property, but the same law regulating the use of the property does not fall into the ordinance or law exclusion. So that seems to me a problem that I maybe you can help me out with that.
Well, and that's a different part of the policy within an exclusion. I think the issue is physical loss. They did not define in this situation. Now, Erie defined loss in their policy, which CNA did not. That, I think, was one of the main bases for the two differences in the opinion. However, I would still submit it's still ambiguous. I think in this case also what's important is even the two insurance companies in their briefs don't even agree on what would be considered a loss. One says total destruction, and the other one says loss of use, but it has to lose functionality. And we have a third. So, and it goes back to the law and the contract said if there's an ambiguity, whether you're reading it in or not, like they're interpreting it loss of use, loss of the premises, physical loss, you have to lose it. And if they would have had destruction in there, we wouldn't be here.
How do we make sense of the period of restoration provisions, which only seem to make sense when we talk about the physical condition of the property rather than what you're arguing about?
The restoration, there were certain measures, and then it really depends. They did have to make additions to the property. There was like the plexiglasses, and they still were closed for a period of time. Certain businesses did have to do certain things, and I think the period of restoration is going to come in later on. Once you find the coverage, then it's going to be factual probably, and that was part of the reason for that whole coordination issue with different factual issues in Tambellini, that this is really just whether you get into the policy to make the claim. There still could be other circumstances within the policy that either limit the coverage or you may not be able to get the coverage depending on the different facts. But this is just whether there is physical loss of or damage to get you in the claim. So then let's say hypothetically the court rules this is ambiguous, you get into the policy. Then the next thing you'd look for is there a virus exclusion? Well, there wasn't a virus exclusion here. In the CNA policy, well, there's no virus exclusion.
Counsel, if we could get back to this issue of the period of to rebuild, repair, or replace. Don't we have to look at all of the provisions of the insurance contract in order to give meaning to any one of them? So if you're correct and there's an ambiguity in the phrase physical loss or damage to covered property, don't we look to the temporal limitations on the time in which you can recover for the loss in order to define what physical loss or damage means?
Right.
I mean, I think that's the hardest part of your case, frankly. I could make the argument that you had a physical loss because of your just inability to use the property for certain purposes. But if I read that phrase in conjunction with the parts of the policy that give meaning to for how long you can recover, that's where I stumble on this interpretation that you're offering us.
So let's assume hypothetically we get around the ambiguity, Madam Justice Donahue. Then I think what happens is the time that it's closed, and then it goes into the functionality, how long you're closed for. Some businesses were closed for 90 days, and then they could reopen. It becomes then a factual circumstance of how long you recover for, and also how much.
So your client's business wasn't closed for that period. I mean, there was takeout and there was delivery, and so consequently, there was access to the covered property, which somewhat goes against the notion that there was the loss of that property.
Well,
how do we deal with that?
It really depends then on the claim. The insurance company will look, how long were you closed for? Were you closed? In this case, in the MacMiles and all the cases, they were all denied the coverage outright. So then
your client might lose, others may not. Others may not have been able to be open for takeout and delivery for whatever the various reasons were.
Correct. Or like I'm not going to get into it. I'll stay away from the dentist. I'll let Mr. Goodrich deal with that. But there's businesses, and that's the thing, the important. That's why I think this physical loss of or damage is really and that's where you get into all these. No one ever got a chance to prove their claim.
Let me ask you this. How do you reconcile the two diametrically opposed Superior Court en banc decisions?
I think the Judge Stabile opinion in MacMiles, my personal, reading between the lines, is Erie defined loss, but also it's basically saying we're going to find all these other opinions around the country persuasive. And because of I forgot the word to use, overwhelming, I think the second opinion,
which his dissent tracked pretty closely his majority opinion
right.
in your case.
And then in the CNA case, Judge Piniella followed that there was an ambiguity in the opinion because CNA didn't have an exclusion. And there was even a footnote in there, I think, that said, if there was an exclusion, we never, ever would have found anything. I think in our opinion, in our case, I forgot who was the fifth vote. There was one person. The reason that came out 5-4 is because Erie defined loss. And I think it's a distinction without a difference, honestly, but I think that's how the two opinions came out, is one defines loss, one doesn't. And in Judge Pinella's concurrence in the MacMiles case, he writes that it was based on the policy. That's the one.
It says it's fact intensive. It doesn't tell us.
What
He just
fact?
tells us fact. Well, what fact? He doesn't tell us what fact. It's very peculiar in searching for the distinction between the cases.
I think it was the definition of loss, that it just never got into it, because then in the majority, in the CNA case, it's really more that there's an ambiguity in physical loss of and use, and they didn't define loss.
What kind of loss, under your construction of direct physical loss, what kind of loss could one of these businesses suffer that would not be physical? I mean, you know, like, I don't know, what is the other category of losses that would not be physical? If you're correct, I'm not sure how anybody would be able to deny that any loss, so long as it's not imaginary, was, anything but physical. What's the dividing line?
It could be. But the problem is the insurance companies somehow went from destruction to physical loss. And that is not the insured's, I would submit, problem, that they've written this insurance policy.
Well, I think, policies morph over time, and just because the language changed doesn't mean the intent changed. Someone could argue that physical loss is the equivalent of destruction. And so, I don't think we apply statutory construction principles to ISO forms. But how about, I'll give an example and you tell me whether you agree or not. What if it was a labor union strike and all of the employees walked off the property and the manufacturer then can't build anything or make anything? Is that a direct physical loss of the property?
If they can't make it, they probably have some other insurance policy to cover it anyway.
Well, but I'm asking you
could,
your interpretation of physical loss. Have they, since they can't put their product out because of a labor strike?
I think you can make the claim, and that's for the insurance company. Then you get into the other provisions of the policy, and that's what we're trying to. Is a lot of there's going to be other provisions of the policy that are either going to be set-offs or claims or something like that. Like in these cases, there could be all the businesses, or not all, got PPP. Some of them may not even have any claims, depending on how that works out.
How would the definition of direct physical loss in this policy be any different if we simply substituted the word economic? So if it said direct economic loss, would it be your position that the two are entirely the same and completely interchangeable?
Yeah, I think then it's actually unambiguous in our favor, direct economic loss.
So what would be the purpose of having this term direct physical loss? Is it just a catch-all to mean all kinds of loss?
That's how one can interpret it, but we're interpreting, and I think it goes back to the contract principle and what Judge Ward did in the original opinion, applying the dictionary terms, and what Justice Musmano said in his dissent in that Cleveland case, that as long as our interpretation or the business's interpretation is reasonable, it doesn't have to be perfect, then the insured prevails. This was and all they had to do was either put destruction, put a definition, which they're not. There's not a lack of definitions in this policy. The policies are 23, 24 pages long. There's exclusions. They could have put a definition. It's kind of like in baseball, you have the foul pole. Well, that's in fair territory. Why? Because there's a definition of it. If they would have defined it, if they would have put, and I agree, you could read it one way, but as long as the interpretation is not unreasonable, the businesses should at least get the opportunity to present the claim. Then you look into the policy and see what are the provisions. This is like the first beginning of the policy, and these businesses, a lot of businesses may not have paid for business interruption.
If employees of your client's establishment one night stole all of the equipment from the kitchen. It was gone. That would be a physical loss, would it not?
You would
Now,
have
it might not be covered because the policy doesn't cover theft.
theft, correct.
But that would be a physical loss. I mean, a physical loss does not require damage. It doesn't require some catastrophic force being, used upon the property to destroy it or damage it.
Correct. In this case, it just arose because of a catastrophe, but it could be from some other thing, and then it's subject to and that's how, when you read the rest of the policy, and that's where in these cases, none of the businesses, all they got was, we're making the claim, and then you get this 5-page letter that lays out, this is not why it's physical loss of or use, we're not paying it, and there's 90 other cases. In this situation, I've not seen a case where they've said, apply ambiguity. And this is like 4 years ago. A lot's changed over time, and I'm sure the insurance policies are going to change over time. But for this specific instance, in this specific argument, the people lost the use of the premises for a period of time, whether it be a week, 2 weeks, whether it be subject to, then you get into that whole civil ordinance authority. There may be different areas that they can recover, they can't recover, but this is just getting into, this is an all-risk policy with a peril that's covered. It's not a fire or something like that.
Where does it get you if we agree with you that what happened here as a result of the governor's order or the pandemic itself, there was a physical loss of use of physical loss of the covered property? Then where does that get you? I mean,
well,
because
first
then of course we have the issue about the temporal limitations on recovery and things of that nature. So where does it get you if we agree with you on this?
Other than canceled by every insurance company in the state, I think it gets us into the policy to make the claim. So have an adjuster assigned, and then they start looking at the other areas. So if there may be an exclusion in one policy or not a virus, something else that applies, they can use that. But in these cases, there's only been 2 things that have ever happened. One, a denial outright, or a denial outright, and then, by the way, we have a virus exclusion, which you don't have here. And it goes back to the ambiguity that if this is not an ambiguity because of I think the fact that everyone can make up or create different hypotheticals just shows how ambiguous this is. It goes back to if they would have had physical damage, if it would say, physical destruction, total destruction, or some definition, physical loss of means destruction or damage to property. They're sophisticated. The everyday person, and I think it gets back to where I started the argument. If you're thinking from a common sense business person who no one reads their policies anyway, when you hear business interruption, your business is interrupted, then you're paying an extra premium, which you didn't have to do. You're forced to be shut down to a natural disaster. Those are things that if the insurance company wanted to, they could fix the problem, but it's their policy.
But it's not just the disaster, right? It's the disaster plus the governor's order. And let me come back to this reasonable person analysis. So assuming you're right that it's ambiguous, which it's a high hurdle, direct physical loss is direct physical loss, but let's say it's ambiguous and somebody might want to explore whether it would mean direct physical loss of use, which is what you want it to mean. And then they read through the whole policy and they see that language about construction, use, or repair of the property. Wouldn't that tell a reasonable reader the word use is here, but the word use is not up there? I come back to that disconnect. I think you responded before by saying, well, that's in an exclusion, so we don't We don't look at that, or can you
Yeah,
explain
well-
to me why that's not material?
Actually, I think if you hear construction, use, or repair, construction means rebuilding something. Repair is doing something. Use is actually like, I think use could be defined in that case to me as going back out to using the premises. That it's not repairing, it's actually using the premises. So I think we may be back here in 4 more years arguing that, but use, you're using the premises. There's no definition of use in the policy. And one other important thing, if they would have put "and" in here, it may have even been different too. The disjunctive, and it gets back to the DeVito case, or other catastrophic circumstances. The or, damage, everyone knows what it means. It's damage to the property. But then what does physical loss of, it has to mean something different than damage because it's or.
Now, so let me get back to my question about what does it get you if we decide, if we agree with you on the coverage issue. Judge Ward, at least, and I think the Superior Court actually went through all of the other provisions of the policy that were otherwise in question here. Don't we have to do the same thing? I mean, you don't win if we say, okay, there's coverage, go back, because it's been back on, on those issues.
There's a remand.
There could be a remand. It really
didn't they decide all of these questions that you're talking about? I mean, they talked about the governor's order. They meaning the lower courts. I don't know. I don't know what it would go back for.
Well,
if we decided there was coverage.
I think, well, it was filed, it could be remanded back to determine that, but a couple things is that this opinion or this case is going to be more encompassing than just MacMiles, and I think that's what the important, that's why I think the important thing is getting into the policy as opposed to all these others, because what would happen if this court says, well, there was no direct physical loss, it's not ambiguous, everyone's out. Not only MacMiles, Ungarean, the Tambolinis, whoever else. If this court holds, yes, there is an ambiguity, that's one. And then I think there's the other 2 issues in the Ungarean case anyway, but that kind of relate to those terms. But then, unfortunately, Grant Street may not win, but other places may win depending on how it applies to their factual circumstances. And that's why I think it's important, unless you get into the policy, the rest of it can't even apply. Whether it applies in this situation, it may not apply to Ungarean, but it could apply in this situation.
But we would have to decide that in this case because the lower courts decided it. We can't stop at with an agreement that, there's coverage. We can't stop there.
I still think that they would recover under the policy. But the issue that was certified, I think that's the most important. But I agree with you, Madam Justice Donahue, about getting into the rest of the policy and looking at it in the full context. It's going to be important, but it could also be, remanded back, because that's not really or it could be remanded back to the Superior Court for a determination, because that issue never really got decided because...
But Judge Ward decided that there was coverage and none of the exclusions applied.
Right,
I mean, you had
I think they don't apply.
ready to go.
I think they honestly don't apply because this was caused by a virus, and they had a virus exclusion, and they didn't put it in. If they would have put...
The governor's order didn't cause them not having access to their property?
Well, the governor's order did, but there's no exclusion because it was caused by... The governor's order was necessitated by the virus.
Well, no, the governor's order was necessitated by the governor's judgment based on the governor's authority under state law. There's no evidence that there was actually virus on the property.
There's no direct evidence, but I think I would submit over time, the virus was everywhere. I was scared to go jogging down the street. that without getting the virus. I think I remember reading somewhere that at Hershey Park you couldn't scream on the roller coaster. People were like, worried about that. So I agree. There could also be a remand to determine whether the virus was there. I think at the Grant Street, if I remember reading somewhere, that there was several incidents of COVID in the building.
But you acknowledge that the governor's program for the shutdown also included the ability to petition for an exception, that exceptions were granted, that businesses were allowed to be open, that some businesses stayed open across the Commonwealth of Pennsylvania during this. So the idea that the virus necessitated the closure isn't true for at least uniformly.
Not uniformly, but also when businesses requested the exemption, they still had to be closed until they got the exemption, I think. So you would.
The point is, they didn't shut down out of a sense of civic duty. They shut down because of the governor's order. I mean, there's no crime in that. I mean, that's a fact, right? You can't divorce the two.
Right, and some just defied the governor's order and stayed open. They paid the fine, I guess, or whatever. So.
Can I follow up on this loss damage dichotomy you're offering us? You're saying damage means damage, but somehow we don't know what loss means, or we know and it means loss of use, rather than that you say. I think they can't be gradients of the same thing. If I have the quote right, I don't know if it's your brief or if your colleague's brief. Isn't the more natural reading of that that they are degrees, that we talk about loss being loss of the thing that is damaged? I guess what I'm asking is this: do you put too much weight on the disjunctive? Isn't the more reasonable interpretation that they are, to use your word, gradients of the same thing? Take a fire. If there's a fire in a building and it's damaged, well, that's damage. Or loss would be if you lost the building in the fire. Isn't that the more natural reading of this language?
Justice White, you just said, I think, something really important. You said what's the more reasonable. And it could be the more reasonable, but it doesn't make our interpretation unreasonable or not something that the everyday common sense person, and in this case the tie goes to the insured, and as long as it's a reasonable interpretation, they should they should at least get into the policy. I agree with you. 8 out of 10 people could interpret, but as long as it's reasonable, or as my good friend Jim Haggerty, who I hope is feeling better, would say, it can't be crap. I could use a different term,
yes,
but
this is a familiar legal principle.
Cooper on insurance. But I think that's the thing. As long as it's reasonable, that's the test that's applied. Whether or not the businesses, obviously, you pay for business interruption. You're paying a premium, and it goes back to you get what you pay for. The businesses could not have every business looks at their policy. Oh, I got business interruption. I'm going to make the claim. The insurance company, oh, no, you don't. It's not. Well, how do they know? And it goes back to the business. The reason they created the virus exclusion in 2005 was because they had to pay all those claims under SARS. And that was the reason it was created. So in this case, Erie Insurance is not short on finding exclusions. I think you could take judicial notice of that in any type of policy. They could have added a virus exclusion to this policy. Then we would not be here. Guess you understand my argument?
I think we do. Are there any other questions? Thank you, Mr. Cooper. We'll hear from Mr. Santarelli.
Madam Chief Justice Todd, Honorable Justices of the Pennsylvania Supreme Court, Fred Santarelli for Erie Insurance Exchange, and with me is Tara Machuzik of the DeBell Weinheimer firm and Bob Horst from the Horst firm. Your Honor, I'm encouraged to hear that we don't have to look at the avalanche of all the other cases that have already come before us in other states. There's 15 high courts of other states. There's all the federal circuits. They've all looked at this issue. But we don't need to just follow them. We can consult them. They're interesting. We can follow Pennsylvania law, this court's law. And there's a case that's cited by my friend Mr. Cooper, Madison Construction. It's a 1999 Supreme Court case. It's one of those cases that everyone cites when they want to interpret contracts or insurance policies. Stewart v. McChesney is another one. And he basically gives us the do's and don'ts of how we read contracts, and insurance contracts specifically. And I think, Justice Sweck, you hit on something about the word use. The word use isn't there. Well, if you look at the Madison Construction case from 1999, what happened there was an insurance policy, and the policyholder wanted to add words after other words. It was a pollution exclusion case, and they wanted to add the words, the pollutant seeped or leaked or dispersed into the environment. And this court said, don't do that. Don't add words to the policy. And that's exactly what Judge Ward has tried to do here, and what MacMiles is trying to do. They're trying to add the words after loss, use of property. And I think that's the fundamental flaw, and it just violates basic rules of how we have to read and apply plain language. Don't add words, and they're adding use of after the word loss. And they're also disregarding a word. I think, Justice Wick, you pointed it out too, the word physical. It means something. It's a physical loss. It's not just a loss in the sense that it could be an economic loss. It says physical. That word means something. We have to give it meaning.
Let me ask you what that word means. For example, my employees steal all of the kitchen equipment from the, I mean, that's the loss of the property.
That's a physical
That's a
loss.
physical
I'll
loss.
agree with you,
Okay.
Justice Donoghue.
Okay, now let's take this example. I have a store on a street in Shadyside in Pittsburgh, and I get to the store one morning, and there are a group of young kids who are blocking the entrance, and they're, making it impossible to enter the store. Isn't that a physical loss of the property? It's not a metaphysical loss. I mean, it's the loss of the property to these young kids who are preventing my entrance.
Well, there's nothing wrong with your property in that instance.
But where does it say that needs to be? I mean, that's what I'm
Yeah.
sort of probing here. I mean, I'm Justice Wecht asks the question, the opposite side of this question, which is what wouldn't be a physical loss. I guess what I just described to you is a physical loss of the property when someone cannot enter their premises.
Yeah, I would respectfully disagree with you. Because
why is that? Because the property is still there?
the property's still there, and the property doesn't have a scratch on it. What was lost
I'm
there?
just talking about loss. I'm
Okay.
not talking about damage.
What was lost there was a physical loss of maybe access to it. Again, you're adding words to the policy. We don't do that. It's the physical loss of the property. The property is the object that you have to look at. What happened to the property? Was it a physical loss of property? And in that situation, it's basically doing the same thing. We're changing the question asked by this policy. You're asking, was there a physical loss of access to the policy? That's not what it says. It's talking about property. What is wrong with the property in a physical sense, as opposed to in some legal sense or some economic sense? I'm not able to use it. And that's the key. And that's the Cleland case. You know, it's been around. It's time-honored, we can say sometimes. But the Cleland case, all we had was a government order. And it was a government order that told people, don't use your property. There's nothing physically wrong with the property itself. And they said, in this court, you know, adopted the lower court and said, no, there's not a loss just because we have a government order. And that's exactly what we have here. But you're losing the access to your property or the use of your property because of a governor's order or any government order. And this could go, I think, Justice Weck, you gave a good example of, if, God forbid, if they made last call earlier than it is now. But if they did, there's obviously going to be a lost revenue, a loss of use. And if MacMiles has a food truck, this policy covers food trucks. If the government entered a new gas emission standards regulation, and that food truck cannot pass it, it can't be used anymore. But there's nothing wrong with it. It's okay. It's sitting in the parking lot. But all they're talking about is a loss of...
I would disagree with all those analogies, and I can't tell you precisely why, except for the fact that everything that you just mentioned involves licensing in some way, shape, or form. So, you know, that being said, yeah, I think it just sort of takes the example a little farther than what we have here, which is in otherwise unlicensed activity, i.e. just being open, that's being controlled by the governor's order.
Well, you may have hours of when you have to close. Like the closing time at a bar is like 2 o'clock. So you may have to close your bar at 12 o'clock.
Well, I'm not sure if that's not an LCB requirement, but which goes to my licensing issue. So I just don't know about that.
Okay.
But that being said,
that's a good point. Licensing is not causing physical damage to property, and that's what I'm going. And this is essentially government licensing to stay open. If you're an essential business, you could stay open. I mean, I tried 3 cases in my office during the pandemic while this court had orders saying don't use courthouses and things.
I tried a case too during the pandemic. What about Mr. Cooper's? What about Mr. Cooper's effort to limit loss of use to the extent physical loss can include loss of use unaccompanied by a physical alteration or some physical impact of the property? He seemed to want to limit physical loss of use to include losses of use due to natural disasters, but not my example of a labor union walkout. How do you respond to that limitation that he's proposing, that not every physical loss of use is covered, some are not?
Yeah, well, you only look at whether there has been an effect on the use of the property, the human activity that can happen on it, if you first have a physical loss to the property itself.
I'm saying, I'm asking you, if I understand the physical loss of use argument, if we adopt it in toto, that is a reasonable reading of physical loss to include physical loss of use, then I would submit then that means any loss of use would be a covered risk under the policy, regardless of what happens, regardless of whether it's a loss of use because of a pandemic order or a loss of use by an employee walkout, anything that, or a loss of use because teenage kids are picketing in front of the property and you can't get through the front door. But when I asked Mr. Cooper that, he seemed to suggest, no, we're only talking about physical loss of uses because of a pandemic or an emergency. Do you see an ability to limit the principle that's being offered here by the other side?
No, I don't see it, and I don't agree with the premise of the question either. I mean, the physical loss, if you want to call it physical, but loss of use is not physical loss of property.
No, but if we say it is, okay. Is there a limiting? What's the limiting principle?
Well, there's,
basically there is none. Any physical loss of use would be covered under the property coverage, unless excluded.
It would absurdly, yes. I mean, that may be where we end up, and we end up with the saltwater taffy place in Wildwood Boardwalk example that we have on page 38 of their brief, where, you know, there's definitely a loss of use because of a bad weather report, their forecast, but the hurricane never hit. So there's a loss of use there, but it's not a physical loss of property in that situation. So I think you have to look at, Justice Brobson, is the loss to the use or to the property, and if we assume loss of use is covered, I mean, who knows? It doesn't end.
Justice Donahue's example would be a covered loss. My example, the union walkout, would be a covered loss.
The emission standards for the food truck would be, I mean, everything's a loss of use. If employees want to strike and not come to work.
Could you address the question I posed to Mr. Cooper? Could business owners buy from most insurers a loss of use policy or negotiate a provision providing loss of use in their existing policies?
So the there are some policy. I think there's a case for homeowners policies where they actually use the word use. So it's not unheard of to put the word use in there in some policies. I don't have it off the top of my head right now, but there's a lot of policies. Like in this case, I think it was a King's Bench petition filed by a major, huge corporation. If you look at their policy, it's a manuscript policy. They negotiate these things. So if you find loss of use becomes a standard, this isn't like you're just helping out, people with standardized policies or you're helping huge corporations. They're going to say, "Oh, we're all in on this now." So, but
isn't business interruption coverage loss of use coverage?
Well,
What else would it be? I mean, that's what
No.
isn't that what you're being compensated for? With the
Good
business
question.
interruption?
And that gets us to the policy. So we go back to basics. So this policy has an insuring agreement in the beginning. Everyone agrees. That's the gatekeeper. You do not go to what are you now unable to do? Are you losing business until you get through the gate? The gate is there physical loss of or damage to property? That's the question here.
That's the one that says we will pay. Begin.
We will pay. It's prominently bold caps, page 1, section 1 of this policy. There's no tricks there. And it's real simple, one sentence paragraph. So if you get past that gate, and that's where none of these cases can get through, and they agree with us there. Everyone agrees. That's the gate.
That's why he wants to get through that gate.
He wants to get through there so bad. And if you get past that gate, then we can look at, Justice Stone, then we can look at, okay, well, there's physical loss of property. What are you not able to do anymore? Well, I can't do business. Well, then that's coverage 3. You're going to get income protection if you get through that gate. And that's what this case is about, getting through that very simple, straightforward, section 1, page 1, bold caps, insuring agreement.
Santorelli, I just want to follow up to the Chief's question. This is a property policy, right?
Yes.
Okay. This is business interruption insurance, so it's business interruption insurance as a result of a loss or damage to property, physical property, right?
Right.
This isn't a general commercial liability policy.
I think there is. This particular policy may have CGL in there, commercial general, but this is a business.
This is a property
policy. Yes.
You can buy general commercial liability policies
Yes.
that include things other than property loss.
That's correct. Okay. Yes. This is a property policy, and at the end of the day, when you were asking the question, did they get through the gate? I mean, did they show that the property suffered a physical loss? It's a property policy, so we have to keep asking that question. Did the property itself, not the use of it, not the access to it? That's where Madison's construction says.
But I think you have Justice Weck pointed out the big hurdle the other side has. You have a big hurdle too, which is the Pennsylvania law that favors the insured on ambiguous policy provisions. And that is a pretty strong principle of Pennsylvania law. You need to show, sort of. I mean, they need to show that their interpretation is reasonable. Your response has to show that it's unreasonable. How is their interpretation unreasonable?
Well, and I'll refer to Judge Ward's trial court opinion, which was then adopted in Ungarean. The only argument they make to say that they had a reasonable, or as Jim Haggerty, God bless him, not crap argument, is to look at this word or. And they say, well, simply because the word or is there, what's on the front side of the or has to mean something different than on the other side of the or. But there's no citation, any rules of grammar or anything. And I think if you look at the Brian Garner modern English usage, I mean, he says or. That doesn't mean that. It can.
You don't necessarily follow Brian Garner.
Well, I've seen it cited in a couple of cases. I figured I'd mention it.
Some of us cite them pretty often.
I think it was Justice Weck, maybe. I forget. But sometimes or, sometimes it is two different things. But you look at the context, and that's what the rules of interpretation. Look at the context. Like if this policy asks us, is that window open or shut? It's one or the other. The context is telling us that. But if it's asking us, is it cloudy or overcast today? All right. Or is this property did it suffer a loss, a physical loss, or physical damage? So the two things on either side of the or can and often do mean some either gradients, or you could think of it as concentric circles, like damage is one circle on the inside, loss.
An effort to be all-encompassing, not exclusive.
Right. It's
Or put differently, it can be a list of like things.
Yeah.
Go to the market and get me apples, oranges, or blueberries.
That's right.
If that were the case, then these would be, again, to use Mr. Cooper's or Mr. Haggerty's or Mr. Goodrich's verbiage, it would be a gradient thing. It would be a gradient of the same thing. It's so.
Sure.
How do we decide then whether to view the disjunctive that way or the way that they're arguing?
You look at it in context. It's if we're talking about doors and windows, they're open or shut. And whether they're open or shut, this is common sense. If they're open or shut.
But if it's a question of how we read it, that makes it ambiguous, and why don't we then read it in favor of the insureds?
Because it's not a question, because you don't get to the ambiguity. And this is Madison construction as well. It says we don't strain the words to find an ambiguity or to look for one. I fully embrace the ambiguity rule if there is one. There simply isn't one here. And the only way they try to create one is to come up with some non-existent rule about war. And a lot of courts, if we look at it,
I don't know if that's fair. I'm not sure it's a non-existent rule. It's a principle. It is a principle we look at when interpreting ambiguous or defining ambiguity. Your better argument seems to be that it doesn't take into account the word physical, and two, if you look at actually how the policy pays for a physical loss or damage to the restoration paragraph, that seems to, if it's only going to pay for certain things, that seems to eliminate the economic loss theory. But again, I don't know. I think your biggest hill to climb is this idea that their interpretation is unreasonable.
yes, and I think it is, because it just defies the rules that this court says. How do we see if something is ambiguous? We look at the words in context. And when you do that here, loss or damage, physical loss or damage, they really are gradients or concentric circles. They're similar. And when I said it's a non-rule, what I meant was the non-rule was that what the trial court said here is that it's always exclusive. That's not a rule. That's like the opposite. It's not always exclusive. And the only way they find and strain to get to a credibility is to follow that non-existent rule. It doesn't say always different. And that's the only way you could think that this is a reasonable interpretation. But that's not the rule.
Mr. Santorelli, at the beginning of your argument, and rightly so, you indicated that we don't need to look at the other states. We can do this just under Pennsylvania law. But we can also take some guidance from other states and how they've handled these same issues. Could you just address that for us?
Sure. Again, there's 15 high courts have said that loss of use or government orders without physical loss of property just simply is not a physical loss or damage to property. And Judge, there's literally hundreds of opinions that have said that have addressed these same issues. I could go through all of them, and they're all throughout our brief, both briefs. And there's amicus who've given us tons of them. But basically, they're all coming down to say, the same thing. They're rejecting this argument, but they're saying the physical loss has to be tethered to the property. It's something that there's something wrong with the property here. Something happened to the property. Now, there are some tests out there, right? Now, they push it to the limits, and they say, well, what about if it's the physical loss of this property is to the point where it's uninhabitable or it's effectively gone. It's as if you don't have it anymore. And the courts have been trying to, grapple with that. And I'll leave you with this. There's a lot of tests and a lot of these opinions, hundreds of them. But if you're asking me, you know, is there a test we should think about if we want to kind of say, you know, what's the rule we're going to put forth that might apply to everyone? And we have hundreds of cases pending right now in the system. The Third Circuit trying to predict what you folks are going to do here.
Which is dangerous.
Which is dangerous, I agree. And I hesitate, that's why I hesitate to, I said, when I'm going to argue this case, I'm going to say what this court says, not what other people.
I lured you into it.
But if you want to send me there, I'll tell you the Third Circuit has looked at this very recently. They had a case called Wilson. And that's one that, you know, if I had my druthers, I'd probably say that's even going a little bit far. But that's one that if you're asking, you know, is there something that we could live with? I think perhaps that's it. And I'll just, you know, and it says that the court rejects the loss of use theory because it is completely divorced from the physical condition of the premises. The businesses lost the ability to use their properties for their intended business purposes because of the governors of the states in which they operate issued orders closing or limiting the activities of non-essential business, not because there was anything wrong with their properties. And when they said, you know, what kind of standard, they say this, the business must therefore must show that the functionalities of their properties were nearly eliminated or destroyed, that the structures were made useless or uninhabitable, or that there was an imminent risk of either of these happening. You know, that's something where it's tethered to the property. Something's wrong with that property to the point where you effectively don't have it anymore. And
is that how you end up agreeing with my hypothetical that this covers the theft from the Grant Street Inn? It's a physical loss of the property.
Well, I don't need that standard. I would agree with you right off the bat. When you said that initially, I said, yes, that's a physical loss.
I'm trying to figure out why you agree with that. I mean, since everything else that you're talking about has to do with a different kind of physical.
Well, there, it's as if the food truck is stolen, right? They stole MacMiles' food truck. That's a physical loss of that food truck.
Well, the policy here covers personal property.
It does, coverage too.
So that's the answer to the question: is the theft of equipment is a theft of is a loss of personal property. It's a physical loss. Only
if you get through the gate. Get through the gate.
You're presupposing that that's what physical means.
You got to get through the gate, though. There's an insuring agreement. See, this policy is set up. You have an insurance agreement. That's the first one. And then you have coverage 1 is the building. Coverage 2 is personal property. And coverage 3 is income protection. But they all relate to this one question. So, yeah, the personal property will be covered because it got through the gate. There's a physical loss of that equipment.
You're saying the insuring agreement is only for physical loss of real property.
No. The insuring agreement is for all 3 of them.
Right.
Right. So real property is the first. And they don't have that part because they don't.
For my question, it was assuming that there was coverage for the non-real property. Yeah.
Right. You have to have physical loss of property, whether it's the equipment. And is that if the employees steal all the equipment, they physically take it, it's gone. I agree with you. I mean, if there's then you go to and say, okay, has there been a loss of business activity? Are humans not able to do business there? That's coverage 3. But there was a physical loss of property in your hypothetical.
Do you want to sum up, Mr. Santarelli?
Sure. I will sum up by saying, you know, let's get back to basics of Pennsylvania law. Let's just read insurance policies the way this court has told us how to read them. Don't add words to the policy. Don't add of use after loss. Don't disregard physical. And we're talking about property. So follow the language of the property, the plain language. Don't strain to try to find an ambiguity. That's Madison construction as well. And let's just apply, you know, common sense and the basic rules of how we read and write. And I think we'll come to the same conclusion that everyone else has come to across the country so far. But we'll do it on our terms, on our Pennsylvania law. Thank you.
Thank you, sir. Let's move on then to Mr. Goodrich. Are you next?
Except he's the Aplt.
Yeah, but we did. You are, so we're moving on to the Ungarean case, though.
Right.
Okay, but you'll go after that. All right. So, Shenmugam? Is that her name? Mr. Shenmugam?
Popped out of nowhere.
It's a little bit confusing because, as noted earlier, we have two different holdings from the same en banc panel in two parallel cases. All right, please proceed.
Thank you, Madam Chief Justice. Kenneth Shanmugam of Paul Weiss for Appellants CNA and Valley Forge, and I'm here with my colleague Jamie Durling. May it please the Court, this case, like MacMiles, presents the question of whether claims seeking to recover business losses from Governor Wolf's public health orders in the wake of COVID-19 fall within the scope of the coverage of provisions commonly found in property insurance policies. It will come as no surprise to this Court that our position is the same as the position of Erie that you've just heard from Mr. Santorelli. The mere loss of use of property does not constitute a direct physical loss of or damage to the property, and any loss or damage to the property must still be physical. And so rather than giving you a big long speech here, I'd like to pick up on the points that were made during the argument in the MacMiles case and address what we think are the key issues here. And let me start with the issue of physical loss of use. Of course, we agree that the basic rule in Pennsylvania, as elsewhere, is that ambiguities should be construed in favor of the insured. But here, we simply submit that there is no ambiguity, really, for two reasons. The first is that the policy, obviously, by its terms, does not cover a loss of use. It covers loss of or damage to property. And so our fundamental submission is that loss of use is simply not what the policy says. And as Chief Justice Todd asked earlier, if an insured wanted to have coverage of that variety, the insured could have sought that coverage, and I'll talk a little bit about the other options that were available to the insureds. But I think the other fundamental problem with Mr. Cooper and his colleague Mr. Goodrich's submission this morning is that there is nothing physical about this loss of use. What it really is an economic loss. And so the other problem here is that the submission on the other side simply doesn't take into account the term physical, as Justice Brobson said. And I think that the reason why this is really problematic was exposed in some of the earlier questioning. The problem is that I think that the insured's theory here proves way too much. And the reason why that is so, I think, was exposed in the colloquy that Justice Brobson had with my friends about why it is that a loss of use here would really depend on the existence of a natural disaster. Mr. Cooper at times during his argument suggested that it would, but you would be reading that additional limitation into what is already an atextual reading of the language of the policy. Justice Weck asked the question about, well, what if there's an order that says no service of alcohol after 1 a.m. or something of that variety? And I think that under the loss of use theory, the economic loss theory of what this policy covers, there's no reason to treat that hypothetical any differently. I think that illustrates why that is, in fact, an unreasonable interpretation. And many of the cases around the country that have dealt with this issue have dealt with arguments of that variety. And what they have said, and I would point this court to a decision from the Sixth Circuit Court of Appeals in the Santos case, which addresses this issue, is that this is really tantamount to a zoning restriction. Take what took place with regard to dental facilities. As the court is aware, Governor Wolf's orders did not close those facilities. It didn't say, don't go into a dentist's office. What Governor Wolf's orders said is those offices can perform only essential emergency procedures. They can't perform ordinary dental cleanings and the like. That is really analogous to a zoning restriction. You know, if a government said, we're no longer going to allow certain properties to be used for elective dental procedures, that's kind of like Justice Weck's example of no alcohol after 2 a.m. And so again, I think that illustrates why this interpretation can't be correct. And I do think that to the extent that the court is thinking about, well, could the policy have used the term use? Of course, one of the exclusions does use the term use. But I'm actually content to rely on the business income endorsement itself. Remember that that endorsement covers the actual loss of business income due to the necessary suspension of operations during the period of restoration. So if you get through the gate, there's been a lot of discussion of gates, if you get through the various gates, you can recover for the loss of business income due to the loss of a use. This is a business income endorsement. But the key point to remember is that the gate here is that the suspension itself must be caused by direct physical loss of or damage to the property. And so you only recover for that loss of business income if you have direct physical loss of or damage to the property. This is, after all, a property insurance policy at its core. And so that requirement is an important prerequisite in order to obtain the loss of business income. Now, let's say you disagree with everything I've said over the last few minutes. I do think that the period of restoration provision eliminates any ambiguity here, and I want to go to the questions that Justice Donahue asked about that provision. The first thing I would say is that the period of restoration language is really part of the definition of the scope of coverage, because the scope of coverage, as I noted a minute ago, covers the loss of business income due to the necessary suspension of operations during the period of restoration. So the period of restoration, as Justice Donahue pointed out, really covers the sort of temporal scope of coverage. And that period, of course, begins with the date on which there is direct physical loss or damage, and it ends on the date when the property should be repaired, rebuilt, or replaced. And I think it is a fundamental problem for the insured's position in these cases that you don't have any repair or replacement in this context, as you would if, say, there was a fire on the property and you had to replace part of or all of the structure. My friend Mr. Cooper referred to the fact that there were precautions that were taken. In many of these facilities, they would put up plexiglass and do all of the things that we were aware of. But I don't think anyone would say that that's a repair to the property. I think what someone would say is that those were precautions that were put in place to prevent the spread of COVID-19 from one person to another. And again, that really underscores why there was no damage to property here. As we're all aware, there were various things that were done. People cleaned surfaces and the like. Again, none of that is something that in ordinary English someone would describe as repair, rebuilding, or replacement. And so I really think that, again, to the extent that anyone thinks that there's any ambiguity here, that the period of restoration provision really addresses that. Now, there's also been some discussion about the absence of a virus exclusion. I would note at the outset that in CNA's policy, there is a microbe exclusion on which we obviously rely, and in our view, that microbe exclusion covers viruses because that exclusion covers losses caused by any non-fungal microorganism. The mere fact that that provision doesn't use the magic word virus is of no moment. But really, our core submission here is that regardless of whether or not there was a microbe exclusion, no inference can be drawn from the presence or absence of such exclusions. And that's for the simple reason that, as this court has said, I think going all the way back to the Miller case, when you're dealing with questions of coverage, you've got to start with the issue of whether there is coverage first, and then and only then turn to the exclusions. And there's a good reason why that is true. Insurance companies adopt belt and suspenders approaches in all sorts of contexts, and they include exclusions, even in circumstances where there is no coverage, just to eliminate any potential doubt about the issue.
Couldn't we, counsel, if I may, counsel, couldn't we look at the exclusions first and save everybody a lot of time if we see from the exclusions, regardless, this isn't even going to be in the ballpark of coverage?
So, Justice Wack, I don't think there's any rigid order of operations when a court considers issues like this, but I think I would urge the court as a prudential matter to start and end with the direct physical loss or damage language and the coverage issue for the simple reason that there is variation across policies. And when you look at these cases, both here in the Commonwealth and elsewhere, some of the cases involve various exclusions, others don't. as the court will be aware, in this case, unlike in the MacMiles case, we're relying on many additional exclusions, some of which are not in the MacMiles policy. And so it's very important, not just for the industry, but also for insureds to have clarity on that issue.
I agree with you about the primacy of the direct physical loss negate here, but I'm just testing this jurisprudential principle you advanced. If you and I have a contract about whatever, and then we list out 10 exclusions, why would it be jurisprudentially inappropriate for a reader to look at those exclusions and perhaps immediately recognize on exclusion number 1, well, what we're talking about here is not within the bounds of this contract, and they can go home?
So I would grant you, as a matter of ordinary contract principles, that that's true. You can rely on any of the language in construing a contract. I would just note one thing that's a little bit different in the insurance context, as Your Honor is aware, which is that the burdens are slightly different when it comes to coverage and when it comes to exclusions. The insured bears the burden on coverage. The insurer bears the burden on exclusions. But again, I actually think that the issue of providing guidance is a really important issue here. And again, even the microbe exclusion in this case is different as between the two cases that are before this court right now. And as the court is aware, there are a number of other cases coming up through the pipeline in the Pennsylvania court system. And so, I do think that the straightest line here to a reversal in our case is to say that there's no ambiguity in direct physical loss or damage, particularly in light of the period of restoration provision. And I think that this court could appropriately rely on both of those considerations.
In the presence of the word use in that provision, is that?
Well, you pointed to the presence of the word use in the ordinance or law exclusion, but I would also point to, again, the fact that the business income endorsement in particular treats the suspension of operations differently from the direct physical loss or damage requirement, as kind of illustrating why you only get to use once you have direct physical loss or damage. And I think that that's another way of reaching essentially the same result. And I don't purport to tell this court how to go about writing the opinion. I think any of these ways of writing the opinion would be appropriate. We obviously want, above all, a reversal in this case.
I say it's entirely possible we were writing an opinion to affirm, but putting that aside.
Well, we obviously don't want that. So anything I could say to help guide the court not to do that. But I think in terms of how to resolve this, I really would encourage the court
start
with respect to focus on coverage.
So in the response to your period of restoration argument in the briefs from the other side is that period of restoration provision relates, it can be isolated, that it doesn't apply to every economic loss flowing from physical loss or use, that deals with specific types of economic loss flowing from physical loss of use. And if we just don't apply it, we can still rule in favor of the policyholders in this case. How do you respond to that argument?
Sure. So, Justice Brobson, I think in all of the hypotheticals that are in the insured's brief, they're hypotheticals about, well, what if there's a part, the person who makes the part's no longer around? You can still easily apply the period of restoration provision. You can just say, well, it extends until the point at which there is replacement. And, if you have a building that can't be rebuilt at that facility, courts have applied that provision and said you get recovery until such a time as you open up at a different location. And I think really the key point to underscore is the point that I made in response to Justice Donahue's earlier question, which is that this is part of the scope of coverage. This is not some discrete provision elsewhere in the policy. I mean, it is a few pages. The definition is in the definition section, but the term period of restoration itself is in the business income endorsement. It's also in the extra expense endorsement on which the insureds rely here. And so it's really, I think, even if the definition itself is segregated, it's really part and parcel of the same provision. And so to the extent that there are edge cases where it may be difficult to apply that provision, the fact remains that that provision still has to be satisfied. It's obviously a very important limitation on coverage. And I would note parenthetically that in all of these policies, at least the policies of which I'm aware, there's also an outer temporal bound. Here I believe it's 12 months on business income recovery, and that really underscores that this period of restoration provision in many cases will do significant additional work. I want to address, Madam Chief Justice, your question about what an insured could have done here. Could an insured have gotten a loss of use policy? I'm not sure that insurers like CNA offer policies in those terms, but they do offer additional provisions. There were communicable disease endorsements that have been at issue in some of these cases, but not others. There was a recent First Circuit case, the Lawrence General Hospital case, that involved a disease contamination provision that a hospital got that potentially could have provided additional coverage. As the court will be aware from the amicus briefs, there were some situations involving pandemic coverage. Perhaps the most famous example involved the Wimbledon tennis tournament, which was canceled, and it turned out that Wimbledon had the foresight to get a pandemic policy which entitled it to a significant payout. And so, I think what I would just say as a sort of broader structural matter about all of this is that this is a property insurance policy, and that's a fact that I think many of the courts have attached weight to. And while my friends on the other side say, well, it's an all risks policy, it isn't just a policy that stops and says you get recovery for any risk. There are pages and pages of enumerated provisions that impose important limitations. So I think that to the extent that there is concern about what this means going forward, I think what it means going forward is that I suspect that insurers will, as a default, impose even clearer limitations, but that it will be a matter for bargaining for insureds, and these are, after all, business policies, to decide whether or not, if they are made available, they want to obtain additional coverage for these sorts of losses. Now, Justice Wecht, you asked a question about the difference between the two cases, and I want to say just a little bit about that to hopefully provide some additional guidance. As the court will be aware, I believe President Judge Piniella, in his concurrence in the MacMiles case, suggested somewhat cryptically that there might be differences in language that matter here. I don't really think that there is any relevant difference between these two cases. The one difference to which my friends in the first case alluded is that in the Erie policy, and I believe that this is at page 59A of the record in the Erie case, there is a definition of loss. It's a definition that I don't think, frankly, does a lot of additional work. It just says that loss means direct and accidental loss of or damage to property. Really, the policy is just structured somewhat differently. It breaks out that definition of loss. Here, the coverage is the same, and I haven't heard any substantive suggestion about why that language would make any difference. As I indicated, there are some differences with regard to the exclusions, but if the court accepts our proposed approach and just resolves the coverage issues, those differences can be left for another day. On a related note, there aren't really any differences in position between myself and Mr. Santarelli. The other side suggested that there are, but let me explain how our definition works in some of these other cases, and again, hopefully this is helpful in providing guidance as to the contours of this position. We would certainly agree that when you have total destruction of a property, that is something that we would ordinarily think of as a loss. And I think Justice Wecht had it exactly right. If you have a fire, sometimes you're going to have a fire that just does damage. Sometimes you're going to have a fire that causes total loss of the property. And while the other side somehow disparages that as like a gradient, the notion being that total destruction and partial destruction can't be treated separately, I don't think as a matter of basic grammar there's anything odd about that. I don't think there's anything odd about saying that a fire could cause loss or damage, and that is effectively what the policy does. That having been said, I do think that you can have loss without damage. In the fire hypothetical, maybe you'd say you have both, because if the building burns down, that building has certainly been damaged, and it's also been lost. The paradigmatic example, I think, is the one that Justice Donahue gave. If you have theft of personal property, property hasn't been damaged in any way ordinarily, but you've certainly lost it. And the policy does provide coverage for personal property up to certain limits, just as it does for real property. So that would be enough if you thought that you had to have, not just concentric circles, but overlapping circles as between these two terms. I will point the court to the Third Circuit's cogent discussion of this exact argument in the Wilson case, recognizing that it is, of course, not binding on this court. But in Wilson, the Third Circuit gave a couple of examples. It gave the example of a stolen truck, like the stolen food truck that Mr. Santorelli talked about. Also gave the example of a house on a cliff. And I do think that when you look at some of the cases, and the amicus briefs in particular point to these cases involving contamination, ammonia, smoke, and the like, those are really all cases where you have property that is uninhabitable. And I think probably the hardest case, and it's not this case, is a case where a property has been rendered inaccessible. Let's say that you have squatters who come into a house and they change the locks. From the perspective of the owner, it feels like there's been a complete loss in that circumstance. Now, why is that not this case? It's not this case for the simple reason that the government orders here, of course, stop far short of saying you can't go into the building. The government order said you can go into the buildings for certain purposes, such as the provision of essential dental services, such as preparing food for takeout in the case of MacMiles. And so this is not close to wherever the boundary is between those two things. But we are, as Mr. Santorelli said, I think content to accept the way that the Third Circuit set this out, which is to define a physical loss of property as, quote, a failure to maintain tangible possession of the structure. And to note that there can be circumstances in which there is physical loss without damage, such as cases where the structure is made uninhabitable. And I think that that actually rationalizes the vast majority of the cases involving different fact patterns, if not all of them, on which the other side relies. And so, again, I think the key point here is that this is not a definition that in any way turns on loss of use. So if you had a situation in which the governor issued an order, and again, this is not this case, but let's say Governor Wolf said, we're just not going to have any dental services during the pandemic. I think we would still say that is like a zoning restriction. That is not rendering the property itself uninhabitable. And of course, government actions themselves don't cause the physical loss. After all, there is in this policy, as in others, the civil authority endorsement, which provides added coverage for certain government actions. When you're determining whether or not there is physical loss or damage, you've got to look at the property itself and what has happened to the property. And yes, if someone takes your property, that's a different case, but otherwise you've got to have some operation on the property itself. And I think the only other thing that I would say, unless the court has any further questions, is that there's been a lot of discussion about this basic principle of Pennsylvania law that if there are ambiguities, the policies have to be construed in favor of the insured. And I recognize that it may feel like there's a certain subjectivity to that, determining whether or not an interpretation is within the bounds of reasonableness for purposes of there being ambiguity. But of course, that canon of construction is one of the fundamental principles of insurance law, and it's a principle that the Commonwealth shares with every other jurisdiction in the country of which I'm aware. I don't think there's really anything unusual about the way that the Commonwealth applies that principle. And this is where I think Chief Justice Todd, to sort of end up where you ended up with Mr. Santorelli, this is really where the case law around the country comes into play. All of the arguments that are being made today have been made in those cases that have been litigated around the country. I've been fortunate enough to argue a number of those cases. And in all of those jurisdictions, you have this same canon of construction, that ambiguities are construed in favor of the insured. And yet courts have consistently said that there is no ambiguity here, relying on the fact that any loss or damage has to be physical and it has to occur to the property. And I really do think that in light of the fact that every federal court of appeals and every state Supreme Court or court of last resort to have reached the merits has reached the same conclusion here, that it would be unfortunate if this court were an outlier. It would be very disruptive for the reasons set out in the APCIA's amicus brief. It would potentially expose insurers to billions of dollars of liability. And I don't think that this court should do so, particularly in light of the fact that multiple aspects of these provisions reinforce that our construction is the correct one.
All right, thank you. Are there any further questions? Thank you, Mr. Shanmugam.
Thank you, Madam Chief Justice.
Mr. Goodrich, you may now assume the podium.
Madam Chief Justice, Justices, this honorable court, if it may please the same. It's pretty tough for an Irishman to be quiet for this long. And there's a couple matters that I want to go through and address, and then I listened to the instructions, Madam Chief Justice. I don't want to be redundant or, duplicious, as my brother Bill used to say, instead of duplicate. But this policy is a 22-page policy. 3 pages are the insuring agreement, 18 pages are exclusions. Not every exclusion applies to every circumstance. So when you're talking about a period of restoration, Justice, that goes to the other side of the argument, the or physical damage. Certain things apply to different circumstances. That's why there's 18 pages of exclusions. Physical loss or physical damage. Now, Mr. Cooper talked about the Cleland case, and they defined it as destruction or ruin. They changed that, and I understand what Justice Brobson said, that things change over time, but we wouldn't be here if they used that terminology, destruction or ruin. They did not. Again, under basic principles, they, being the insurance company, wrote the policy. We can't negotiate the terms or conditions. We take it where we leave it. They wrote the policy. That's what the policy says. Physical loss or. It doesn't say physical loss and. It says physical loss or. And, as Justice Musmano said in the 1958 decision, this case is not that difficult. All you need is a dictionary. Unfortunately, CNA didn't use a dictionary when they wrote this policy. There are no definitions within this policy. None. When you read stuff, there's usually a definition section to help, to make sure there are no ambiguities. But when you're looking at it, what is a layperson supposed to do when they get a policy? I bought an all-risk policy. Has business interruption. Has civil authority. Okay, I'm covered if something happens. No, you're not, according to CNA. And when you're dealing with a property policy, and when you're excluded from using your premises, that's a property right.
Well, see there, can I stop you there?
Yes, sir.
Mr. Goodrich, you used the word use. You inserted the word use like Judge Ward did, and the main problem I'm having with the argument is it seems like you need to win. You need to do either one of two things or maybe both of these things, and that is to add that word use that's not there, and then go back and delete the word physical. So we talked about that great jurisprudence, Brian Garner. Another great jurisprudence was the late Olivia Newton-John.
We're going to get physical.
Not let's get economical. So we knew what she was talking about. Physical, right? So
we did not need a dictionary for that, Justice.
Why don't we know what they're talking about here when they say physical? They don't say economical. I mean, don't we have to give that word the meaning of everyday lexicon?
Well, loss means deprivation. That's a terminology of loss.
No doubt.
So physical deprivation means I can't use my property. It's not, with all due respect, I'm not the brightest bulb going here, but I read physical loss of or physical damage. Well, they can't mean the same thing. So it has to be something, that word's superfluous. So what's it mean? Because strict construction of contract law is every term has to be taken, has to have a meaning. So physical loss cannot mean physical damage.
Mr. Goodrich, the physical, I appreciate what you said. I think you're on the right path in the sense that you say physical loss can mean I can't use my property. The problem here is your clients could use their property. The property was usable. It's just that the governor issued an order that told you it's more of a taking. It's more of a governmental taking than it's a loss of property. You agree your client could use the property.
Limited. He had limited use of it for emergencies only because of the emergency code. Emergency code that they restricted it, and he was deemed a necessary provider. He could not do. I've looked at his balance sheet. I've seen his substantial losses because he couldn't do cleanings, he couldn't do lab work, he couldn't do a lot of other stuff that cost hundreds of thousands of dollars of damage because he was only allowed to do emergency procedures. So, to use your word, he had a taking, but he had a deprivation of his property rights because he could not use his facilities to the full use and extent that he could beforehand.
Sounds like a real loss. It sounds like a real loss. It sounds like an economic loss. But how does it sound like a physical loss?
He physically could not use the building, which ended up having a derivative indirect, which is accessible and permissible and payable under the policy. He could not make the money because he could not physically use his dental office. He could not sit out on the street and do lab work. He couldn't do out there. He didn't have his x-ray machines. He didn't have his dental tools. He couldn't do that. Couldn't take x-rays. Couldn't do crowns. Couldn't do molars. He could not do that because he needed to use his physical office to do that. It's not like us during the pandemic that we could work from home, we could work on a computer. It's unique, and you have to look at what his loss is based on his ability to use his premises. And I think that's where the issue, that's why it's a physical loss. Physically, he could not use the building. Now, I looked at the policy, I looked at the key words here. I mean, direct physical loss of or damage to the covered vehicles. It's the word or. Or is not there. If the word or was not there, we wouldn't be here. If the word virus was there, we would not be here. Okay, and that's important because in the 18 pages of exclusions, the word virus does not show up one time. Again, it was very easy. It's foreseeable. Go back to the Bible. Go back to biblical times. You can go all the way through history. Pests, viruses, stuff has happened. It's not like this, you know, they're claiming now, oh, this was so unforeseeable. We didn't know this was going to happen.
There was no locust exclusion here.
No, there was none of that either. But there was no virus either, and most of the companies put that virus exclusion in after the SARS in 2003. They started in 2007 putting that in. They could have put it in. It's not there. If it's not in basic construction, it's not there. If it's not there, it's covered. It's an all-risk policy. That's what my clients relied upon. And interestingly, you know, whether or not, and this, again, Mr. Cooper spoke about this, so I don't want to dwell down this rabbit hole, as Mr. Haggerty talked about in the briefs. But it does not have to be the best interpretation. It just has to be reasonable. Again, physical loss of is physical, not being physically able to use it. And Madam Justice Donahue, in the Friends of Danny DeVito, you set forth the reasons. Page 37, you set forth why this is different than the flu. You know, people may say, well, the flu's not covered. Why is this covered? Well, the flu's been around for a long time. This was a pandemic. It was a disaster, something we have never seen before in a long time. We had no vaccines. We had no buildup of immunity we didn't have any tracing. We didn't know how long it was. We knew that this was something that was dormant, that 1 out of 4 people didn't have symptoms. It could be gestation period of up to 14 days. We found out 4 years later that it's like the flu now. I personally had it 3 times. Okay? I know that every time I had it, my symptoms were less. Okay? Because the body naturally started building up immunities. So we know now what we didn't know then. But with all due respect, we have to look at what was going on then when everything was shut down. Pandemonium was going on in this country.
But Mr. Goodrich, why does that matter from a policy construction, what the cause of the loss of use was? Because under your construction of the policy, any loss of use is a covered loss. Pandemic, a labor union walkout.
I disagree with that.
Okay, so tell me how loss of use is limited.
Well, I think in the labor union lockout, you can go get new employees, and the availability to use your property has not been restricted. Under the governor's edicts, orders, your property rights were restricted because you could not use the property. And that's where that's different.
I know it's a different factual. I'm trying to understand what is the policy language that supports distinguishing that between one covered loss of use from another covered loss of use. What's the policy language?
The policy language just says physical loss or two. That's all we can go on. That's it, because there's no other guiding light within the policy. It just says physical loss of, and we got to look at the facts. I think fact by fact scenario too. Also sometimes, because the old law is you change the facts, you change the law. But in this case, what we know and we know our policy clients endured is that they were precluded from using the premises. And the issue is, under the policy, whether or not they were precluded had an economic detrimental effect on them or a property right effect. And it did. And that's it. That's what the issue is. And, you know, in the DeVito case, quite frankly, also, a point that's been glossed over, the DeVito case already recognizing how the COVID-19 causes damage to property. That's within the opinion itself. I didn't write that. And that's what makes the PA law different than all these other jurisdictions that they're talking about. We had in Friends of Danny DeVito written, talked about that this is a disaster. It's a kind of natural disasters that happen, like fires, hurricanes, floods. That's what this is like. We all know they're covered under policies. They're covered under insurance policies, property policies. So why isn't this? It's just, again, it's a common sense approach. The Scranton case, I do want to talk about this, the Cleveland case, for a moment. Mr. Haggerty, my dear friend, cited that there was no opinion. There was an opinion, if you look into it and you find it. And the opinion in that case that was written states that the policy was specifically written against all direct loss by fire. That was the policy terms in that case. Wasn't physical, all direct. So, and it was a direct result of a peril. That is what the opinion says. I have it right in front of me right here. Because most people, when you pull this up, it just has the two-page dissent from Justice Masmiano. And Justice Masmiano states in that case, all you need is a dictionary. All you need, because he looks at the civil authority claim in that case and says that it says all perils. So that's why he dissented in that case. But that case was specifically written for all direct loss by fire. Again, if you use the term destruction, you use the law, or decimation, whatever you want to use. That's a physical issue. That's different than what happened in that case. That case differentiated because the fire, they're concerned about fire from a hurricane because the water was all messed up. So they precluded one from the other, and that's how that case came about. Now, the interesting thing in our case is lack of definitions, and that's what brought us to this case to begin with. Direct, which is not defined, is defined in the Webster's Dictionary as one point to another without deviation. Physical, of or relating to a natural science, material existence. Loss, destruction, ruin is one definition. Losing possession of or deprivation. Dr. Ungarean lost possession under the orders of the governor and was deprived of the use of his property temporary. The policy does not say it has to be 100%. Policy doesn't say anything. Damage can be loss or harm resulting. Loss or harm. The harm is he couldn't use his property. It's not outside the box here. We're not getting esoteric in these. These are straight out of the dictionary. Again, loss equals use. Again, when you're looking at a reasonable interpretation, and we set forth this in the reply brief that was written, Erie, CNA, and us have three different definitions. I submit that Erie's and CNA's are reasonable. They say ours is not. Physical loss under the Erie policy means total destruction. Under the CNA, physical loss of is loss of use, i.e. total elimination of functionability. Our definition is partial or total loss of use. I submit to you, all three are reasonable. Again, we don't have to win. We don't have to be 80% compared to 20%. It just has to be reasonable. Does it make sense? The insurance provider wrote the policy. Our clients took it. It's all risk, and even that. So that's the one thing that I really wanted to bring up. And the other argument, and then I'll talk about the exclusions in a moment, is the Fayette County case that held that merely accepting other jurisdictions' non-binding decisions amount to an abdication of the court's judicial rule. It's the old claim my mother Mary used to say, just because they did it doesn't mean you're going to do it. This is the Commonwealth of Pennsylvania. You decide what the law is, not other people. Now, civil authority coverage, three-prong test. Civil authority prohibits access. We have that here. Government's orders. Limited access due to physical loss of or damage to property other than insured premises. DeVito tells us virus was everywhere. We know it was everywhere. There's no one that can say exactly where it was at, but if you look at the Fauci decision, and it's set forth on page 37 of the DeVito case, it talks about other properties have been affected. Third prong, physical loss or damage to property caused by resulted from covered loss. Government's orders. All three prongs have been covered. And I'd like to note, before everybody's crying wolf here, that this is going to cause billions of dollars of damage. The physical authority policy is only limited to $25,000. That's the policy limits in that. So, and again, 80% of the covered cases in these types of cases are already gone out the door because they have a virus exclusion. So you're looking at a very small window of what the cases these actually are. Unfortunately for us if we win, but I mean, that's the reality of it. So there's a small group of cases that are actually there. Again, 22 pages of policy, 18 pages of exclusions. Not every exclusion applies to every case, which will get us to where we're at right now. The consequential loss exclusion is usury, because if you look at it, it would preclude any recovery under the policy for business income, extra expense, or civil authority. That's basic contract law. You can't apply to that. The acts or decisions and ordinances of law. Justice Weck, you brought this up. Acts or decisions is intent of what you're doing if you destroy it or you do nothing. It's similar to a mitigation. You got to mitigate, you got to do stuff to take care of it. The laws and ordinances, if you read that, deals with construction cases. That was set forth by Judge Ward and the Superior Court decision. It talks about building reuse, building use or ordinances. It's very basic. You have a deck that's 20 years old, you got to redo it. First off, if you use it like for a business and you can't use it, it's got to be redone. That precludes. And the upcharge for getting stuff redone. That's what that deals with. I already talked about the Bible. We're not going to talk about that anymore today. The SARS virus, we talked about that. It's foreseeability on the policy. If it's not excluded, it's included on an all risk is our position. And financial cries should be done with. I have nothing else unless anybody has any questions for me.
Any other questions? Thank you, Mr. Goodrich. And before you depart, Mr. Cooper, Mr. Goodrich, Mr. Shanmugam, and Mr. Santarelli, those were outstanding arguments. Your clients were all exceedingly well represented. I often say when you gentlemen argue here that we should give CLE credit to the lawyers in attendance. in insurance coverage, but.
That's at the PBA, Your Honor.
Yes. Excellent job. Thank you. Thank you all. call the next case, Mr. Minner?
Bradley Herold as executor of the estate of William L. Herold versus the University of Pittsburgh, representing the university, Ms. Amy Cole, representing Mr. Herold, Mr. Robert Bailey.
In this case, we are asked to determine whether the Occupational Disease Act's exclusivity provision, which requires employees who suffer from an occupational disease to seek benefits for their disease under the Act from the Workers' Compensation Appeal Board, applies to an occupational disease which manifested 15 years after the worker's final exposure to the hazard, such that the worker's civil claim for damages against his employer in the trial court is effectively barred. Please proceed.
Thank you, Justice Todd, and good morning. May it please the court. I am Amy Pohl. I'm joined by my colleague, Jean Sofer, who had the great fortune to retire recently and before the argument was scheduled.
Congratulations.
I am very honored to be here to represent the University of Pittsburgh today. The university is asking this court to uphold the exclusivity provision in Section 303 of the Occupational Disease Act, which I will refer to as the ODA. Section 303 is not ambiguous. It is not optional, and the ODA is an active statute. And when an employee like Mr. Herold has an occupational disease claim against his employer, like the university, the exclusivity provision at Section 303 of the ODA states that the ODA shall operate as a surrender of an employee's rights to any form or amount of compensation or any method of determination thereof. It is not a matter for the trial courts. As this court recently recognized in the Franzik opinion, exclusivity is the linchpin of the workers' compensation system, and the statutory language is the pole star. And in nearly 100 years since the ODA was enacted, the university is unaware of any decision of this court finding an ambiguity in Section 303 of the ODA. In fact,
is TUI on the block here? Can you win even though TUI's out there, or do we need to overrule TUI?
TUI did not interpret Section 303 of the ODA.
Right. Is there a distinction between the Workers' Compact and the ODA?
The university argues, Your Honor, that there is a difference between the Workers' Compensation Act, or the WCA, which was at issue in the TUI decision, and the ODA here.
What is that?
Well, let me just refer to the court's decision in the Barber case. In the Barber case, the court looked at the exclusivity provision of the WCA and the exclusivity provision of the ODA, and in fact found that the ODA's exclusivity provision, Section 303, is stronger than that of the WCA's provision. The language is different in the two exclusivity provisions. In fact, the Barber court noted in interpreting this section, Section 303, that Section 303 clearly states an acceptance of the Act operates as a forfeiture of the employee of any and all common law causes of action that the injured employee may wish to pursue. And since Section 303 is not ambiguous, the courts cannot disregard it in order to come to a different result, just because the courts would prefer a different result.
It seems a lot like Franzik. That seems a lot like Franzik, so I'm just wondering, post-Franzik, what's left of TUI?
Well, Your Honor, I mean, we're not here on the WCA. There was a very specific portion of the WCA that was interpreted in TUI that's not at issue here. One thing to know about the TUI decision is Mr. TUI was voluntarily retired. Mr. Herold also is voluntarily retired. Under no circumstance would either of those gentlemen be permitted to receive compensation under the WCA. That's not the case with the ODA. We know from this court's decision in Republic Steel, where Justice Cappy indicated that someone who does not have an economic loss, such as a retiree who has no loss of earning power, may not recover compensation under the Workers' Compensation Act. Justice Cappy in the same decision said that's not really true for the ODA. The ODA doesn't preclude a claim for compensation as it would in the WCA. Rather, the ODA, the loss of income, or a situation where someone is retired, would only go to the amount of benefits that person might be able recover. And I think, Justice Weck, your point about the Franzik case is very important and also is somewhat applicable, although that case did interpret the WCA, not the specific provision of the ODA that we are here before the court today. Your Honor, in your opinion in Franzik, noted many of the important principles that underlie the workers' compensation system in general. You know, although they are separate acts, both the ODA and the WCA are within the workers' compensation system. The ODA is still active, it's not been repealed, and it does provide for the exclusive jurisdiction of the workers' compensation authorities.
Counsel, let me ask you about that, because I have to admit my confusion about why we're even talking about the Occupational Disease Act here. If you look at the Workers' Compensation Act, Section 301(2), the C2, it says those types of injuries to which it applies, which are those exposure to hazards after June 30, 1973. Okay? If you look at Section 303A of the Workers' Compensation Act, it says that when the Workers' Compensation Act applies, it will be the exclusive remedy. I won't read the... So why isn't the Workers' Compensation Act the exclusive remedy for those cases in which the injuries arise after June 30, 1973?
Thank you, Justice Donahue. The ODA is still applied today. It was recently...
I'm just asking you. I mean, I'm reading two sections of the Act, one of which says when the Occupational Disease, the Workers' Compensation Act begins to apply, which is June 30, 1973, and the exclusivity section that says if it applies, it is the exclusive remedy.
I respectfully disagree, I think, with that interpretation for several reasons. First of all, they're not identical statutes. The ODA was not repealed. And although there is an interpretation that is relied upon by the Applts from the Pulaski case, indicating that one of the reasons that the ODA was not repealed at the time of those 1972 amendments to the Workers' Compensation Act, which added occupational disease to the Workers' Compensation Act. But one of the reasons that the ODA was not repealed at that time was to account for individuals who have diseases that develop post-1972.
But what does that have to do with the language in Section 303 exclusivity provision of the Workers' Compensation Act that says anything that this covers provides the exclusive remedy for those claims?
Well, Your Honor, the ODA is still an active statute. I don't think you can bypass it or ignore it, and it does have stronger...
Why is that?
Well,
I mean, if we have a later amended statute that says that it is the exclusive remedy that applies in situations where the Workers' Compensation Act covers, then it's the exclusive remedy.
Yeah, again, I respectfully disagree that the WCA just undid the ODA with those amendments.
Well, I'm grappling for what exclusive means then. I mean, if this doesn't mean what it says, what does it mean? This says it is the exclusive remedy for occupational diseases resulting from hazards arising after a certain date in 1973.
Yeah, you know, Your Honor, I think that it's important to recognize that it's really for the legislature to say whether or not the ODA is still active or not.
But they do say it. I mean, it says after that, this was an amendment that was passed after the Occupational Disease Act. It says a date on which it becomes effective for certain types of injuries, and then it says in those situations it is the exclusive remedy.
You know, I respectfully just don't read the language that way. I know we may need to agree to disagree on that. There are subsequent cases post-1972 applying the ODA. And so to say, well, the WCA is the only act we need to look at is...
Exclusive doesn't mean exclusive in the Workers' Compensation Act.
No, I'm not saying that. I'm saying that here the ODA offers an exclusive remedy that could potentially provide compensation for Mr. Herold. One thing to note is that under no circumstance would Mr. Herold ever be entitled to compensation under the WCA.
Well, is it possible that the exclusive remedy reference in the WCA is more focused on, under the Workers' Comp Act, the limited damages as opposed to civil trial damages?
Well, Your Honor, under the exclusivity provision, are you asking about the WCA?
I'm asking about the WCA, suggesting that it doesn't preclude application in appropriate cases of the ODA.
Right, I think that there are cases where the ODA...
But I'm making that up. I haven't seen that anywhere. That would just make sense to me. Can you explain if there's any basis?
That's not what it says. What it says, it is in place of any entitled to damages in any action at law or otherwise on account of any injury or death as defined in Section 301C1 and 2 or occupational disease as defined in Section 108, which as I defined it, those arising after June 30th, 1973.
But I don't read that language, Your Honor, and I don't think we can read that language to say it absolutely upends an otherwise existing statute. It doesn't specifically say it overrules the ODA. Yes, it will apply to exposures post-1972 under the WCA, but...
Two grand bargains?
So,
there's a grand bargain under the Occupational Disease Act and a grand bargain under the Workers' Compensation Act, and never the twain shall meet?
Your Honor, yes, they are both part of this, the grand bargain. They are both active statutes that are part of the grand bargain. It's the ODA is social legislation, which embodies a compromise reached by the legislature.
Exclusive in Section 303 of the Workers' Compensation Act to actually not mean exclusive remedy.
No, Your Honor, respectfully, this Court's already interpreted Section 303 of the ODA in the Barber decision, saying it is stronger and separate from the exclusivity provision of the WCA.
How do you have two exclusivity provisions? That's what when I started out my questioning, I said to you, I will admit my exclusion. Because let me just go back to the beginning of where my confusion started on this. Had you proceeded with a defense under the Workers' Compensation Act, to me would have precluded your argument. So you didn't skip it. I mean, I know the Commonwealth Court, but bear with me on this. Mm-hmm. Instead of applying the Workers' Compensation Act, we're applying the ODA, which you're now asking us to interpret in a way that is inconsistent with the other grand bargain.
Meaning the WCA.
And see, as I see it, after June 1973, you don't have that conflict. You have the Workers' Compensation Act that covers occupational diseases.
Honestly, Your Honor, it's two statutes within the grand bargain.
Aren't we required, counsel, when we're presented with two apparently applicable statutes, neither of which has been repealed, to attempt to give them both effect, so that in a circumstance like this, the two are part of a comprehensive no-fault system, and that the way they operate in a case, I suppose, like this one, is that where the workers' comp would not provide, again, assuming TUI is not there, which we could talk about, but where workers' comp is not going to be providing a payment opportunity for the claimant, that the ODA would afford some monthly payment, however minimal it might be, but the ODA would kick in the appropriate circumstances. Wouldn't that be a way in which both of these statutes can coexist?
I do think that both statutes can coexist, Your Honor.
As long as neither one of them is the exclusive remedy.
Right. Let me just back up a little bit on the Workers' Compensation Act. In this case, and in many mesothelioma cases where it's a latent disease, where someone has retired and has no loss of earnings, We know from Justice Cappy's decision in Republic Steel, they can never receive compensation in those situations. The ODA provides a path. So to that point, the two acts can work together.
Well, I think what you're saying is the exclusive remedy in the WCA only applies if you are entitled to relief under the WCA. Is that what you're saying? Because here he isn't.
He's not entitled to relief
So
under.
therefore, since he's not entitled to relief, the exclusive remedy doesn't apply and he can be under the ODA.
And that's the ramification of TUI, right? Because
Which was an excellent opinion.
TUI basically said it's exclusive unless it's not covered, which is an interesting construction that the court gave in TUI, that the workers' compensation is a harbor only for a period of time, and after that period of time, it's no longer exclusive.
Well, I mean, the WCA, of course, has different language.
No, I'm saying, but that's what TUI said. TUI limited the exclusivity provision itself by saying it's only exclusive if you bring it if it manifests within a certain period of years, and then it's no longer exclusive.
And that was what the TUI decision said.
Right, and
that's consistent then with this, with our argument.
well, it's consistent with your argument. Basically, is you're saying the reason that he is barred by the workers' comp, but he has this other statutory remedy under the ODA, but he's also barred there too.
Well, Your Honor,
but the barring language is not the same.
Correct. And let me get back to what the court has accepted this appeal on, which is interpretation of the ODA. Compensation, actually receiving money, is not a prerequisite to application of the exclusivity provision in the ODA.
But the temporal limitation is.
Well,
why isn't 301C precludes the exclusivity provision? Does it not? Because he doesn't fall within the act because he was diagnosed 15 years to the latent disease. 15 years later, yet 301C only provides 4 years. So that would cut him out of the ODC. He's already precluded from the workers' comp. Therefore, pursuant to his Pennsylvania Constitution, right to access to courts, he could file a civil complaint in the Court of Common Pleas. What's wrong with that?
Your Honor, exclusivity is not contingent on the various limitations to receiving compensation.
Then why do you have limitations on acts if it's not applicable?
There are many limitations. Not every employee who goes to the workers' compensation system ultimately recovers compensation or ultimately recovers an award. There may be any limitation, number of limitations.
Hey, let's follow this. Let's probe this. Mr. Herold, does he fall within the ODA?
Yes, he does. He has an employer-employer relationship with the two prerequisites for exclusivity under Section 303 of the ODA. He has an employer-employer relationship, and his injury occurred during that relationship, and he has an occupational disease.
But
disease
how
means
does he
it's
have an occupational disease if it's only from 4 years from last exposure, and he's 11 years too late?
The occupational disease definition is separate from, it is part of the exclusivity provision, which is not contingent on these other limitations.
So if we were to rule your way, does that open the door for everyone who previously has been denied compensation as a result of the temporal limitation of 301C?
I think that there are significant policy ramifications for denying the university's position. Any employee, if it's true that compensation is a prerequisite to the exclusivity provision, any employee who does not get compensation, regardless of whether it's an occupational disease, will come to civil court.
It's not compensation of being a prerequisite. It's does the ODA, is that the exclusive primary jurisdiction here? But the primary jurisdiction is restricted by the temporal limitation. It's almost like a statute of repose.
It is like a statute of repose, but a statute of repose similar to this would isolate civil liability for a certain category of defendant, and that's exactly what this litigation does. It makes the exclusive remedy, this at least gives a remedy to a litigant. In the statute of repose situation, someone who has an action or a claim against, say, a builder who has built a building with a latent defect has no claim. Here, there is a pathway to compensation.
Through the Court of Common Pleas.
No, the pathway to compensation here would be through the exclusive processes set up under Section 303 and the ODA, which is the Workers' Compensation Authorities. So I understand your point, Your Honor, about Section 301C providing a temporal limitation. Now, we've argued, and the university has argued in its brief, that reading the straightforward language of 301C indicates there was a potential for Mr. Herold to receive compensation even under that temporal limitation because his disease manifested within 4 years of the date of last employment. Yes, 301C provides a temporal limitation, but I don't believe that the exclusivity provision of 303 is contingent on some of those limitations. There are many limitations that we have in the law generally, that we have in the workers' compensation system that don't ultimately give compensation to an employee.
That's every statute of limitations does that. Every statute of limitations says you have to bring your claim within a certain period of time or you can't bring your claim. You have to lodge an appeal to the Commonwealth Court from an administrative agency decision within 30 days or you lose your appeal. It's always, if you don't do something within a period of time, your claim is lost. It's not that your claim is lost under this statute. It's your claim is lost. Your exclusive remedy is to bring that claim within this period of time. And I think that's where I'm struggling with a little bit with TUI, although I'm not sure we have to deal with TUI in this case because the language of the exclusive provision is different in terms of compensable disability or injury, which you probably want to talk about.
In terms of 301C, Your Honor?
Right.
Yeah, so the language is different in 301C as compared to the 301C2 language considered under the Workers' Compensation Act. So the language in 301C, of course, refers to compensable disability or death resulting from an occupational disease occurring within 4 years of the date of last employment in such occupation or injury. Now, again, Your Honor, you don't need to even get to 301C if you're applying the straightforward language of 303 and the exclusivity provision. But if you do get to 301C and need to consider whether or not Mr. Herold would be compensated, a plain reading of 301C, as the university has argued in its briefs, would indicate that Mr. Herold has an ability and a pathway to compensation because his disease did manifest within the 4-year period. And just to circle back on the WCA and the ODA and these two provisions, again, the exclusivity doesn't hinge on whether or not, is it 4 years, is it 300 weeks? The primary jurisdiction in the forum that is to determine these particular questions is the Workers' Compensation Authorities. It's not really a question for the trial courts. This gets back to the issue of primary jurisdiction, which ties into all of these issues. It's not these questions about, is it an occupational disease? How do we determine when his disease manifested to determine whether or not it's 4 years or 300 weeks or whether it's 301C2 or whether it's 301C or whether he can get compensation at all? All of those factors are reserved for the Workers' Compensation Authorities. Both sides...
Primary jurisdiction would simply mean that the common pleas action is stayed and there's a referral to the agency.
Exactly, Your Honor.
And that's what you're okay with?
The university asked for that in this case, Your Honor.
Okay.
So if there's a question about one of those two prerequisites to Section 303 exclusivity, is there an employer-employee relationship, and is there an occupational disease at all? Those two items and issues about timing, issues about the extent of the disease, issues about the manifestation of the disease. Yes, those are items that in the first instance should go to the Workers' Compensation Authorities. I agree with you, Your Honor. Under the case law, which we've cited, Greer, Lord, and some of the other cases, those courts did determine that the best course of action would be a stay so that those decisions could be made by the Workers' Compensation Authorities. That didn't happen here. We did ask the trial court for a stay, and it was denied.
Counsel, do you see anything inconsistent between interpreting this statute differently than the Workers' Compensation Act? And I'm specifically referring to TUI. Don't you see anything, or is there nothing inconsistent about saying that under the Occupational Disease Act, the lack of compensation for an injury suffered does not mean that you can go to the courts of common pleas, where under the Workers' Compensation Act you can.
I don't believe that the two acts conflict, Your Honor. And interestingly, this court addressed that issue, I believe, in the Barber case, where it looked at both the exclusivity provision of the WCA and the ODA and said very, very clearly and strongly, the statute in the ODA, the exclusivity provision in the ODA is stronger than that of the WCA, and clearly states an acceptance of the act operates as a forfeiture by the employee of any and all common law causes of action. I'll divert a little bit and mention that the Toohey case was a case involving mesothelioma. There was discussion amongst the court about, well, these people can never recover. They'll never be able to recover, and therefore we must be able to give them some sort of a remedy. First of all,
where does that come from? I mean, the legislature has the. It may be distasteful to all of us, but doesn't the legislature have that power?
That's exactly right.
We may not like it, but it's not our job to say it's inconceivable. Isn't that right?
That's exactly right, Your Honor. And let me just also say, from a factual standpoint, it's false to say Mr. Herold was never going to get compensation for his injury. He is already receiving compensation from all of the manufacturers of the products that exposed him to asbestos. The university did not make those products. They happen to be located in university buildings where he worked.
It's possible the legislature had that in mind, realizing that folks are going to be pursuing these manufacturers for meso or asbestosis, and do.
Right, and I think that that actually falls in line with the statute of repose point, that there are areas of the law where the legislature has limited liability or excluded liability in the civil trial courts for certain categories of defendants. Here, the legislature has limited liability or isolated liability, or at least isolated a process against a specific category.
And the quid pro quo is it's no fault.
Correct.
Yeah,
there are instances where an employee brings a workers' compensation claim, but really the injury is the employee's fault. An employer, it's no fault. The employer, sometimes employees do stupid things. They put their hand in a chipper, and the employer is still going to pay in those cases.
Is going back to the statutory construction issue in Toohey, isn't your answer to the Toohey problem that if we interpret it in Section 301C of the ODA the way we interpreted it in Toohey, it makes a nonsensical sentence? Isn't that the simple answer? Is the language is different, and if we define it to mean the same thing in this case that we did in Toohey, the sentence makes no sense.
Yeah, so I don't even think you need to get there, Your Honor. But
I understand, but I'm just trying to help you with your answer to the Toohey problem.
Sure. So 301C, yes, the interpretation of the word "it" as interpreted by Toohey under 301C2 it's different language in 301C.
It would make no sense.
It makes no sense, and it also, moving down in that language in 301C. It also, the very clear language of 301C says that the occupational disease, if it develops within 4 years of the date of last employment, it doesn't use the word exposure. So it's sort of there's sort of two arguments there within 301C. It doesn't make sense to interpret it the way the Aplts have suggested, because the language is different from the Toohey language, and the temporal limitation is different, and the language of the temporal limitation is different as well.
Counsel, I don't see any reason why we should be attacking or distinguishing Toohey to reach a correct result in this case. Am I wrong?
Fundamentally, I don't disagree with you, Justice Todd. I mean, Mr. Herold would never have recovered under the WCA. So how Toohey interpreted the WCA is really not relevant.
Right, it's beside the point.
It's beside the point.
But the Commonwealth relied on Toohey. That's the reason why we're talking about Toohey, is the Commonwealth Court relied on it. And so your argument is the Commonwealth Court committed error because they relied on Toohey.
Correct, and the way the Commonwealth Court committed error is they injected those other pieces of a different statute, the WCA, in interpreting what is otherwise unambiguous language in the ODA.
They didn't pull Toohey out of thin air. And the Commonwealth Court doesn't actually take exception to the manner in which you are interpreting Section 301C. But they looked to Section 303 and relied on the alternative analysis of TUI, which is it can't possibly be that the legislature intended for the most injured employees to receive no compensation. And that's what they relied on from TUI and why they looked to Section 303. Correct? I mean, it's, you know, it's not like they were, they didn't try to rewrite Section 301C.
They did not try to rewrite 301C. I do disagree, as an aside, Your Honor, that they interpreted 301C correctly or that they interpreted that 4-year period correctly. But that said, where the Commonwealth Court erred is finding an ambiguity in Section 303, the exclusivity provision, where none really exists. I mean, the court here in Barber has stated it is stronger and it precludes a common law cause of action. In terms of your point about, well, the Commonwealth Court is finding that the legislature didn't intend an absurd result because these are people who could never, because they have the most severe injury, could never recover. I disagree with that from a factual perspective because how do we know that someone with mesothelioma can never recover? In fact, if the court were to read the temporal limitation as written in 301C, the university is of the position Mr. Herold met those conditions and would recover under the ODA. So there is, of course, several statements in the TUI decision about providing benefits to the employee, and there's a remedial purpose to the workers' compensation system. And while that might be laudable, the law nonetheless does not allow us to jump from a liberal construction to benefit the employee to sidestepping a statute altogether. And that's what the university feels Mr. Herold has done here. He has sidestepped the exclusivity provision and the exclusive processes available to him under the ODA in bringing his civil lawsuit. And to Justice Brobson's point, the remedy may be a stay. The correct answer may be a stay. But in any event, his claims are within the exclusive jurisdiction of the workers' compensation.
So what happens if you get your stay and you go back to common pleas court, they stay it, it goes over to workers' comp for determination of let's say notwithstanding 4 years after employment, you litigate the heck out of that, and you argue, no, it didn't manifest within 4 years of his last date of employment. He's out of luck under the ODA. What happens then?
Well, respectfully, Justice Brobson, the university believes his disease did manifest within that 4-year period, and he would be entitled.
Well, I know and I appreciate, you haven't been sworn in today, but I appreciate you're an officer of the court. But it would not be unheard of, at least this week, for an employer or workers' compensation insurer to take an alternative position in the administrative setting than what they take in a courtroom setting. So so I'm just, and you may have other defenses that you could assert, but I guess I'm querying. We stay it, it goes over, and are you going to concede coverage?
That certainly is an option for the university, Your Honor. I honestly can't speak to how our Workers' Compensation Council would approach the case, but we believe that his disease manifested within 4 years. And that
maybe I'm misunderstanding something. Do you feel that that you need to make a promise that there's going to be relief at the end of that rainbow? I mean, because that seems to me to be an argument that's consistent with the TUI majority's view that it's for this court to impose some equitable overlay on top of whatever the statute provides. And my problem here, and I guess I'll ask opposing counsel, perhaps, absent a constitutional claim, perhaps under the remedies clause, for example, how is it our job to afford relief that the legislature apparently denied? Well, let me just stop there and see if you have anything to respond with there.
Well, clearly the court is not here to legislate, and
but isn't that what TUI did?
Well, again, we're not here under the WCA, which is what the specific provision that was
Well, we're
that
forced
was
to wrestle with it because
Correct.
of what the Commonwealth Court did here.
right. I mean, I think that there are some nuances in TUI. One thing that was confusing is TUI didn't consider the facts in that Mr. TUI was never going to recover under the WCA, and so his claim would be excluded no matter what. Here under the ODA, that's not the case.
Well, that's why I brought that up, and then Justice Wecht, I think, appropriately came in and said, you shouldn't concede anything.
Right.
But part of your argument that you have been making in this case is he recovers under the ODA. That's your argument, and a lot of the questions you're getting from the justices and is fair in light of TUI is what Justice Wecht just said: is why is that argument important to you? Why is it important for you to establish he can recover under the ODA? I mean, that you keep saying that. You say it today. You said it in your briefs. Why are you saying that?
Why am I saying he can recover under the ODA? Because he can. We feel that he can recover under the ODA. And
What if he can't? What if he can't recover under the ODA?
Even if he cannot recover under the ODA, Section 303 exclusivity applies and requires that his claim for occupational disease against his employer, not every claim that he may have. He may have claims against manufacturers where he can get compensation. But his claims against his employers need to be brought through the workers' compensation processes. And as Justice Wecht wisely stated in the Fransett case, that exclusivity is the linchpin of the whole system. It's not the court's role to reconstrue language just because the court believes an alternative interpretation would address certain unintended consequences of the law, because rather the task of perceived deficiencies in changing the statutory scheme, that's all left to the legislature. That's not something for the court to rule on. And the fact that the court is maybe unhappy that there's a latency period involved, that this is a terrible disease, which we can all agree on. There are other instances in the workers' compensation system where employees suffer terrible diseases and terrible injuries. They don't get to bypass the workers' compensation system. So why is protected class status given to mesothelioma plaintiffs? And that also, from a policy perspective, Your Honor, makes it very difficult to come to grips with the compromise that underlies the bargain here that the university and other employers are part of.
What about, excuse me, just to interrupt so I can ask my question. So we have the Workmen's Compensation Act, and then we have this opinion in the TUI case that now has the workmen's compensation paradigm treating workers differently under the WCA than they do on the ODA. And obviously the legislature knows about the TUI case, and they didn't make any changes, so maybe the legislature is thinking today that we're going to straighten the problem out.
You're correct. There has not yet been legislation addressing the TUI decision and changing the language of the WCA or the ODA. My understanding is that those activities are occurring. They just have not yet been enacted in the legislature. So I can't stand here today and say that the legislature has sort of remedied or changed the language to either address the TUI decision or, on the flip side, to repeal the ODA. And so we have to live with the statutes as they exist right now.
I understand you said TUI is not applicable to the case at hand because it's under the workers' comp. But why should this court not consider the analysis as applied in TUI to the workers' comp to the temporal limitations of the ODA such that he does not fall within the provision, once again, can seek relief, constitutional right to relief in the court through Court of Common Pleas?
Yeah, very simply, Your Honor, the temporal limitations in the ODA and the WCA are quite different, and we tried to put in one of our briefs. The language is quite different.
One's exposure and one's, but so either way, there's a limitation, and if an individual, in this case, Mr. Herold, is excluded as a result of that limitation, why can't we apply the same analysis that we provided to TUI, who exceeded the 300 weeks limitation of workers' comp?
It really all gets back to the underlying intent of the legislature, Your Honor, with respect to the workers' compensation system. There are many limitations. There are many employees, not just Mr. Herold or Mr. TUI, who are precluded from actually recovering compensation because of a temporal time limitation, because of a statute of limitation, because of any number of limitations. That doesn't mean they can bypass the workers' compensation system altogether.
It's not bypassing it, it's being precluded from enjoying it.
They may not receive compensation under the Act, but they have to abide by the processes set up by the Act. So there are plenty of instances with employees with horrible injuries, burn injuries, chemical exposures who do not recover under the Act. They don't get to enjoy the Act. But that's in the nature of the global policy compromise.
Well, if there's a fix needed, it comes from the legislature, not from us. Isn't that the simple point?
Simple point. You are exactly right, Justice.
Isn't that also true with overruling Chewy from a legislative perspective? That case has been out there since 2013.
Well, Your Honor,
I mean, how long, are they supposed to take a look at this and decide? I mean, as I sit here today, I would be under the impression that they thought Chewy was correctly decided, because here we are 11 years later, and there's been no legislative action with regard to undoing what the Chewy court did.
I can speak only a little bit to that, Your Honor, in that I'm not involved with the legislative efforts underway. I do know that legislation was proposed through House Bill 1234 to change the time limitations and to change some of the language of the Workers' Compensation Act to address this problem and bring back exclusivity under the Workers' Compensation Act. I do not know whether or not legislative activities have happened with respect to the ODA. I just don't know that.
I suppose when they do that, then the question would be answered. But, I mean, until then, it seems that we've answered the question under the Workers' Compensation Act to their satisfaction over 11 years. I mean, they could decide to do otherwise, but they haven't.
Well, my understanding is that some of those legislative activities were suspended in part because of COVID, and that they haven't yet revisited.
And I would speculate that the current legislature is the least likely to undo Chewy. So, I mean, if we want to speculate, but I mean, I'm not speculating as to anything. I know that in 11 years they've done nothing with Chewy.
Yeah, and I mean, again, I know not to keep beating a dead horse, because I would like to go on and speak a little bit about the policy ramifications. But again, Mr. Herold and Mr. Toohey would never receive compensation under the WCA. So the WCA is a little bit beside the point. They would never receive compensation under the WCA. They do have a potential pathway for receiving compensation under the ODA. Again, it's the university's position that the receipt of compensation is not prerequisite to the exclusivity provision. But in terms of does the WCA even matter for this case, well, Mr. Herold was voluntarily retired, and we know from this court's decision in Republic Steel he can't get compensation under the Act because of that. I'd just like to address...
Counsel, before you go there, I just want to we keep going back to Toohey, and I want to make sure I understand what Toohey said. Sure. Didn't Toohey rely on defining what the word "it" means?
Yes. It looked only really to Section 301C2 of the WCA.
And in reaching the conclusion that a time-barred workers' compensation claim only means you're time-barred from filing a workers' compensation claim, you can go outside of the Act after the time bar comes into effect. If this court hadn't interpreted the word "it" the way it interpreted it in Toohey, it never would have gotten to that result.
That is correct.
And how can you interpret the word "it" here in the ODA provision consistent with how this court interpreted it in Toohey? Am I wrong to focus? Because every time the justices keep asking you that question, you don't go there.
No. Yeah, Your Honor. So we have a long discussion of this in our briefs.
Right. You have like a chart or something like that.
How about this? I mean, 1201, Section 1201. I'm talking about the ODA here. Actually, the Act shall be called and may be cited as the Pennsylvania ODA. It shall apply to disabilities and deaths. So pretty clear what it means there. Is that an answer to Justice Robson's question?
We haven't looked at it that way, Your Honor, but it is pretty easy to interpret. We'll say
it there is it there, but what about it in 301C? 301C. If you put the ODA in it there, how does that sentence read?
It just doesn't. It's not grammatically correct to say whenever compensability or disability or death is mentioned as a cause for compensation on this act shall mean only compensable disability or death. Rather, the it means compensable disability or death. And again, our briefs have laid this out with
And that's
underlining.
different language than what was at issue in TUI.
Correct. Slightly different language from what was at issue in TUI.
Slightly more clear?
Slightly, we would say slightly more clear. And again, going back to the Barber decision, the Supreme Court has said the exclusivity provision in the ODA is far clearer than the WCA, and it is. That language is very different as well.
Counsel, the Commonwealth Court didn't disagree with you on the interpretation of the language differences in the Workers' Compensation Act and the ODA, but you know, they did hearken to the fact that in TUI, this court rejected the statute of repose argument that goes hand in hand with this notion of, you know, not being temporal litigation. That's where the court used that analysis, that it can't possibly be that the legislature intended to exclude the most injured workers from compensation. I mean, that's what they rely. I mean, that's how the Commonwealth Court got to where it got. So your argument would have to be, you disagree that they could look at 303 and come to the conclusion that they could, you know, reach the conclusion that the TUI court reached, that the legislature could not possibly have intended to exclude these most injured workers.
Correct, because 303, as we know from this court's interpretation of that specific provision, 303 of the ODA, is much stronger than any of the language in the WCA, in that it acts as a forfeiture of the employee's right to a common law cause of action. Now, within the workers' compensation system, whether or not that employer gets compensation, does not get compensation, that would be dealt with by the workers' compensation authorities. But as a sort of a threshold matter, the court in Barber and the very clear-cut language of Section 303 operates as a forfeiture of the common law cause of action and requires that the matter be sent to the Workers' Compensation Board. If I can just touch for just a few minutes on a couple of the policy issues, to consider the ramifications of allowing employees who don't like the limitations on their compensation and workers' compensation to just bypass the system and take it to a civil trial court. Not only does that run afoul of the doctrine of primary jurisdiction, which we've discussed already, but it violates the compromise that is underlying this entire workers' compensation system. The university and many other employers rely on that compromise. It's been in place for decades. Employers like Penn State, Temple, who have joined us as amici here in this particular matter, Pittsburgh Public Schools, the Philadelphia Public Schools, the Philadelphia Housing Authority. These are all employers who are now grappling with this issue about employees who have occupational diseases who are coming back and suing in the trial courts. And these employers, from a policy perspective, frequently do not have primary liability coverage for these claims, because those primary liability policies often exclude claims for employees. That, too, harkens back to this grand bargain and the compromise. Part of the compromise was that employers would participate in a workers' compensation insurance program. In fact, if an employer does not, violates that compromise and does not participate in a workers' compensation program, then the employee can file a civil lawsuit against the employer. But as part of that compromise, all of these employers, and they're not industrial employers. These are schools and institutions of higher learning. It's all employers in the Commonwealth, relied on this system, and part of the system being the workers' compensation insurance program, to allow some employees to take their claims out of that system is just, and bypass the exclusivity, is just a violation of that compromise. If there are no other questions, I'll say a few concluding points about the university. The university is an institution of higher learning. Many of the members of the court know the University of Pittsburgh well. It's not a commercial enterprise. The university does not manufacture asbestos-containing products. It happens to have equipment that Mr. Herold worked on in the scope of his employment in its buildings that may or may not contain asbestos-containing components. Contrary to the arguments of the appellee, Mr. Herold had an occupational disease, mesothelioma. He stated in his complaint it was specifically related to his occupation. Therefore, he falls within the exclusivity provision of Section 303. His claims against his employer needed to be brought in the workers' compensation system. He was disabled. He suffered an injury as a result of his exposure. Contrary to appellee's arguments, he did not work in the education industry. He was an operating engineer repairing mechanical equipment in the buildings at the university. The exclusivity provision of the ODA applies. It is unambiguous. And changing course now, after almost 100 years, and finding that it is not, that it is ambiguous, would be very detrimental. It would have a detrimental impact on employers. The fact that Mr. Herold does not believe he can ultimately receive compensation in the workers' compensation system is not the bar to the application of the exclusivity provision. And with that, the university would respectfully request that the court reverse the Commonwealth Court and uphold the exclusivity provision of Section 303 of the Occupational Disease Act.
Thank you. Thank you. Let's hear from Mr. Daly.
Madam Chief Justice, members of the court, my name is Robert Daly, and I'm here representing the Herold family, along with my co-counsel Carla Gattilla and Scott Marshall. Simply put, the Occupational Disease Act definitively does not provide a path to relief or compensation for Mr. Herold in this case, despite what has been said here today. He has no path to recovery. And that is relatively straightforward for several reasons that we can talk about later. But the main issue, getting to Justice Dougherty's comments, is his disease developed more than 4 years outside his date of last exposure. And so if it goes to the workers' compensation authorities, they're going to deny the claim.
Could you clarify, is it last date of exposure or last date of employment?
It's last date of exposure. It's these terms have always been interpreted to be last date of exposure. And it's last date of exposure to the hazard.
Why are you saying they've always been Workers' Comp Act says last day of exposure. The ODA says last day of employment.
Workers' Comp Act says last date of employment, but
no, the very first, it's the other way around. The ODA says last day of employment.
If you look right, it does, but the Workers' Compensation Act says employment during which exposure occurs. So the ODA has been interpreted as the date of last exposure as well, universally. And I think the reason for that is because you could have two employees with similar exposures. One retires, one does not. And now one will have a claim under the ODA and one won't because of that.
Let me ask you a similar question that I asked opposing counsel. Absent a constitutional claim, which is not part of this case, why isn't the General Assembly allowed to put people out of court? You may not like it, I may not like it, but it's irrelevant what I like or what I think is bad, quote, policy. If they put somebody out of court and there's no constitutional claim, why do you have a remedy?
Well, I would disagree that there's no constitutional claim here. We have raised a constitutional claim under both articles.
Is that before us today?
Yes, under both. Well, I think it's before you because we've raised it to your point. Article 3, Section 18, Article 1, Section 11, the Remedies Clause. But I think it's worth talking for a minute about Article 3, Section 18 to address your question. And it requires us to step back to 1915 when the Commonwealth decided to implement the Workers' Compensation Act. Well, the Commonwealth could not do that without a constitutional amendment because of Article 1, Section 6 of the PA Constitution, which gives us all a right to a jury trial. And so the only way to put in place the Compensation Act in 1915 was to also put in place or adopt a constitutional amendment. That constitutional amendment was Article 3, Section 18. And that constitutional amendment says, in exchange for reasonable fixed compensation, employers can no longer bring lawsuits against employees can no longer bring lawsuits against their employers. And defenses will be given up by the employers, and it will be a no-fault system. But the key cog in Article 3, Section 18 that's been overlooked is reasonable compensation. Mr. Herold's compensation under the Workers' Compensation Act is zero. His compensation under the ODA is zero. As this court said in Toohey, it is inconceivable that the legislature, in enacting a statute specifically designed to benefit employees, intended to leave a certain class of employees who suffered the most serious of work-related injuries without any redress under the Act or common law.
And that's, counsel, that's the, I'm all ears on constitutional claims, believe me. But that language about what we may think is inconceivable seems to bump up against the principle concisely stated by Thurgood Marshall to William Brennan as they walked down the stairs of SCOTUS one day, when Marshall, following argument, turned to Brennan and said, they get to pass stupid laws. So if we think it's inconceivable that they could pass such a mean-spirited law, why is that either here or there? I mean, if that is what the bargain that they struck, isn't the remedy to go to the legislature and say, this puts people out of court? It's rather than us saying, golly, it's just inconceivable, so we're going to add an equitable exception to the statute.
Well, I think we're not asking you to add anything to the statute, because I think the statutory interpretation itself leads to the conclusion that Mr. Herold's claim is outside the Occupational Disease Act. And I think that's the case for a variety of reasons. The main reason being that the interpretation of Section 301C, the temporal limitation, which says compensable disability or death, is does not include compensability or death that exists outside, that develops 4 years after date of last exposure.
That's what that says.
Yes.
But the compensable disability or death language does not appear in the exclusivity provision. It's different language.
So the exclusivity provision, Section 303, is another interesting point. It does not appear in there. But I don't think you even get to the exclusivity provision, as Justice Dougherty suggested, until you determine whether you're within the scope of the Act. And Section 101 and 301 together.
Well, that's dangerous, right? Because the General Assembly could have granted effectively an exclusive remedy for a category of claims, but then through the scope provisions also limited the kind of claims that are permitted.
That's correct.
And so why don't we go to the exclusivity provision, which basically says any damages, any disability, any civil liability. It doesn't say civil liability covered under this Act. I mean, because here's my concern. If we interpret it the way that you're interpreting it, then people will just blow the statute, and they'll wait. And once their claim is tie-barred under the ODA, they'll file a civil claim in common pleas court.
I think that is a risk that is not, from a practical point of view, present in this case or present in any mesothelioma case.
But you concede it's present if we interpret the exclusivity provision the way you want us to interpret it.
No, because if an occupational disease develops within 3 years after the date of last exposure, and I choose for my client to wait to file a civil lawsuit, well, the defendants are going to raise the ODA as a bar. And that claim is going to be found to have been covered by the ODA because it did develop within 4 years. And then the Workers' Compensation Act would apply too. So the Workers' Compensation exclusivity and the ODA exclusivity would both bar a claim if people simply choose to wait.
And I think it's unlikely potential plaintiffs would choose to wait given the short lifespan ahead of them.
Right. I don't think anyone would wait when they develop an occupational disease, a fatal occupational disease like mesothelioma. But turning to the exclusivity provision, Section 303. So Section 303 is written in terms of a contract. It even mentions the word agreement. And essentially what it says is, with regard to Mr. Herold, Mr. Herold, you give up your right to file a lawsuit in civil court in exchange for compensation available to you under the ODA. That's what it says. You surrender your rights and you get something in exchange for your surrender. However, under the ODA, Mr. Herold gets nothing there's no recovery available to him under the ODA because he's outside the 4-year window.
I'm sorry to beat this horse, or I just want to be clear on something. Are you telling us today that, again, putting aside whether anyone finds that very distasteful, okay, putting that aside, are you saying that the legislature lacks the power to do that?
Do what specifically?
Put him out of court.
Yes, because it would be unconstitutional under Article 3, Section 18.
So I just don't see that as a preserved claim in this case. I looked at the statement of questions presented.
Well, as the Aplts, we're making a response, so we don't need to preserve that claim. This is one of the defenses that we're giving to their argument, that their interpretation would be unconstitutional. So it was not our claim to make, it's our claim to raise in defense to their argument.
Yeah, I'd be very interested in a remedies clause argument, but I just don't see it in this case.
Well, I think we've raised a remedies clause argument to a certain extent, and also an Article 3, Section 18 argument, which I think might be the more appropriate constitutional provision here.
And the most straightforward.
Article 3, Section 18 is very straightforward. Reasonable compensation is required. I think it is preserved. We don't have an obligation to bring it before you because they're the ones bringing this case. We're offering the constitutional justification if you need to get there, but you don't, because an interpretation of the statute leads you to the conclusion that Mr. Herold's claim is outside the statute.
Your response to my question was very helpful, actually. Your argument is, as I understand it.
I hadn't quite completed my response, but
no, rarely does anybody get that opportunity.
That's fine. I'm going to get there eventually, but go right ahead.
Your interpretation of the exclusivity provision or the grand bargain is the exclusivity provision only applies for occupational diseases that manifest within 4 years of the. I think the statutory language here is pretty clear, within the last date of employment. I know you're saying courts have interpreted it, but I'm going to go with what the language of the statute says, last day of employment. You're saying if it manifests after the 4 years, then the ODA doesn't apply.
Correct.
Who determines whether an occupational disease claim falls within, if there's a dispute over that manifestation, where does that issue get resolved?
I don't think it's a matter of a question of primary jurisdiction, if that's what you're getting to. I think that's the type of decision that does not require special expertise from an administrative agency. This is not like I've been before you before on solar power cases. This is not where we have a heavily regulated industry where the PUC can provide technical expertise. This is a simple matter of statutory interpretation where you take a date of retirement, which in Mr. Herold's case was July 2015, the date of his diagnosis with mesothelioma, April 2019. And then this is what has been
4 years of his last date of employment.
This is what's been overlooked. It's not from the date of the diagnosis. It's the date under the ODA. It's the date from compensable disability or death. So there's been no determination here of a compensable disability. And as we know from the cases, compensable disability is economic in nature. Mr. Herold had retired from the workforce with no chance to return, so he was never disabled.
Okay, so you're not arguing, I just want to follow up and make sure, because I think I now understand your argument. You're not arguing that, let's say under the workers' compensation law, you have to file your claim within 120 days.
Sure.
Right. You're not saying that if for some reason a claimant fails to file within 120 days, that some grand equitable principle would apply and they should now be able to file in the court of common pleas.
No, we're not asking for an exception in that regard.
No, I know, but that's the distinction you're drawing.
That is correct.
Is we're not saying that every limitation the General Assembly places on the ability to access the act is unconstitutional or somehow not a valid power.
That's right. This would be unconstitutional if it were unconstitutional as applied to these facts. It's not a de facto unconstitutionality. And
so how would so in your view the General Assembly would have had to create, or for your claim to be subject, would had to have if they wanted to cover all occupational diseases and create essentially a statute of limitations of 4 years.
I think what the General Assembly did in the Workers' Compensation Act and the Occupational Disease Act, as part of the grand bargain, it chose to limit employers' no-fault liability. It chose to limit their no-fault liability at 300 weeks in case of an occupational disease under the Workers' Compensation Act, and it chose to limit their no-fault liability at 4 years under the Occupational Disease Act. That's part of the grand bargain. We're going to limit, we're not going to give you unlimited no-fault liability. We're going to give you no-fault liability to a certain point. Beyond that, it's at-fault liability. So now we have a civil case, and people have treated that. I was here before TUI.
Is that a gift?
It's not a gift. It's not a gift. We have a burden of proof now.
No. Why is it a gift to give an employer no-fault liability?
Well, so for example, if there were unlimited no-fault liability, oftentimes you have a case, a mesothelioma case, where medical expenses can be millions of dollars.
No, but you agree prior to the workers' compensation, there was unlimited fault liability. There was unlimited. They could have gone in the court of common pleas, right?
Prior to the Occupational Disease Act?
Right.
Yes.
Okay. So I'm trying to figure out why you're saying gifting to what did the employers get in return for this gift of 4 years of no fault liability?
Limitations on damages. That's part of the grand bargain.
During the 4 years.
Well, no, the claim itself must arise.
I understand. During that period.
Beyond that, there's no fault liability. No fault liability is over.
And unlimited damages.
Damages as determined by a jury, potentially zero damages. Unlimited opportunities to raise defenses, fault-based defenses, comparative negligence defenses, state-of-the-art defenses they would not have under a no-fault regime. They can defend these cases, and they do quite effectively, and they have since 2013 quite effectively. If we don't go into court and the jury starts writing numbers down, we have to prove complicated scientific issues of causation, negligence, all in the setting of not only negligence defendants, but perhaps products liability defendants as well. So it is not, we're going to go into court and shoot a layup now. It's a difficult task, and I don't think that should be overlooked. So, but back to your exclusive remedy, Section 303. There's a surrender of rights that have to be given. But you have to get something for that surrender. And under the ODA, Mr. Herold gets nothing. So there's nothing to surrender. He does not, therefore, have to surrender his rights. And therefore, he's outside the exclusive remedy provision as well. Even though, as Justice Doherty and others have said, the 4-year period is also applicable here. And so TUI referred to the 300 weeks as a de facto exclusion to the coverage of the Workers' Compensation Act. The Herold Commonwealth Court referred to the 4 years as a de facto exclusion to the Occupational Disability Act. We're not asking for exceptions. We talked about the Franzik case, Justice Wecht. I know you discussed the Franzik case. The Franzik case and the Barber case are completely different from this case. Why? Because Ms. Franzik, who unfortunately was bitten by a dog at Target while working, she had a claim that was compensable. I thought it was Target. But either way, she got bitten by a dog. She got mad at her employer for not figuring out the owner of the dog, and so she couldn't sue the dog's owner, and she sued the employer instead. And this court said, no, we're not going to graft that exception onto the act because you have a claim under the act for the dog bite itself, for the scarring, for the medical bills, for the wage loss. Barber, the claimants asked for an exception because of intentional conduct by the defendant, rather by the employer. This court again said, we're not going to graft an exception for intentional conduct because the Barber claimants also had valid claims under the Workers' Compensation Act of the ODA. So that's the fundamental difference.
I guess the premise of what you just said, it's reasonably put. There seems to be a premise to what you're saying is that it's our duty, or at least our power, to, quote, engraft, unquote, some remedy that the legislature chose not to provide. And unless we're convinced by whatever constitutional argument you may have here, I'm just continue to struggle with this, and I don't fault you for thinking you can go there based on what TUI said about, et cetera. But I'm struggling with this idea that it's in our prerogative to just have this freewheeling equitable domain where we engraft remedies where we think the legislature's done something just not fair.
Yeah, I don't think you and I are speaking the same language here. I'm not asking for an equitable remedy. I'm asking for the court to interpret the statute such that the claim falls outside the scope and coverage of the ODA, in which case a civil case could proceed. And this would not be the first time that this court has done it. It's happened in Greer, it's happened in Lord, both ODA cases. And those cases said that, hey, if these claims are not covered by the ODA, then a civil action can occur.
Counsel, if we accept your argument and rule in favor of your client, to what extent do you think we need to rely on TUI or not discuss TUI?
Well, I think initially there was a question asked, are we asking the court to overrule TUI? No one's asked that particularly, but if you rule in favor of the
Except
university,
perhaps Justice Wecht.
who perhaps no, I mean Justice.
Which was not, by the way, an "oh golly, let's do this." It was a majority opinion.
It was a well-informed statutory construction, construing the word "it" in the exact same way as this court should.
I wasn't around.
In the exact same way that this court, but I know Justice Todd was, in the exact same way that this court should construe it here. And so, if you rule in their favor under the ODA, you will functionally eviscerate TUI. That will be the end of TUI. And what will happen, and we know what will happen if these cases are remanded to the Workers' Compensation Bureau, they'll be denied. We see there, we have an amicus brief from Darlene Data. Darlene Data's case was sent to the was sent to the Workers' Compensation authorities, and they rejected it. They rejected it on time limits, and they rejected it because it's not one of the 4 diseases in the savings clause, and you'll find that at section 992 to 999 of the record if you care to look at it. So we know what will happen. They'll be turned down. So there's no need to send things back to the Bureau. This case can be interpreted just as TUI can on statutory construction, and I actually think, perhaps contrary to Justice Brobson, if you read our version of it into section 301, it's the exact, section 301 of the ODA and section 301 of the Workers' Compensation Act, though not identical, are very, very similar. And section 301 of the ODA reads, whenever compensable disability or death is mentioned as a cause for compensation under this act, it shall only mean compensability or death resulting from occupational disease and occurring within 4 years from date of his last employment in such occupation or industry. Now, I would say such occupation or industry informs that, such occupation or industry in which you were exposed to the hazard, getting back to the employment versus exposure argument.
Read it with the act.
Well, I will. I'm going to do that now because I think it actually makes perfect grammatical sense. Whenever compensable disability or death is mentioned as a cause for compensation under this act shall mean only compensable disability or death resulting from occupational disease and occurring within 4 years of the date of his last employment, etc. That flows, and again, no one told me there would be grammar, but TUI applied the Chicago Rules of Style to substitute this act for it because it was replacing the immediate preceding noun. As the Commonwealth Court also pointed out, it is singular. The university's interpretation, compensable disability or death is plural, so it would not substitute for a plural. But I just think it reads perfectly fine.
Except under the rules of statutory construction, the singular means the plural and the plural means the singular.
But that interpretation would also mean that act would be compensable disability or death, right? I mean, it's at best non-intuitive because wherever compensable disability or death is mentioned as a cause for compensation under this act, then it, so you're saying it is this act, so that you'd substitute, this act shall mean only compensable disability or death. How does an act mean death?
This act shall only mean compensable disability or death resulting in more than 4 years from the date of the last exposure. So, in other words, when we say compensability for disability, when we say compensable disability or death, you need to know that's shorthand for compensability for compensable disability or death occurring within 4 years from the date of his last employment in such occupation or industry. That's where this act substitutes in, and that's what this does. It says we are not going to write all those words all those times, but we are going to say that shorthand, compensable disability or death, add on to that within 4 years. Similar to Section 101, you see where it is replaced by this act quite easily in 101. So I think it's consistent. It's consistent with how this court interpreted statute in TUI, in TUI, the Workers' Compensation Act. I think TUI does, in fact, while maybe not directly controlling the case,
Does inform your analysis.
vastly informs my analysis and informed the Commonwealth Court's analysis and should inform this court's analysis as well.
Could I ask you, Mr. Daly, there's a difference of opinion as expressed by you and by Ms. Attorney Pohl as to whether your client actually could recover under the Act. Does that matter for our ultimate analysis here? As a factual argument, you're saying he wouldn't recover under the Act.
I think if our client could recover under the Act, then the Act would govern. If he had a claim under the Act, then the Act would govern. But he does not have a compensation under the Act, and that's the problem here.
And you define could have a claim to not mean he's time barred.
I think his compensable disability or death in this case, and there's nothing to the contrary in the record, developed more than 4 years after the date of his last employment. He was never disabled by his mesothelioma because he never lost occupational dollars, which is where disability under the compensation system is measured. So he was never disabled by his mesothelioma. He did die as a result of it. That was more than 4 years, even after the date of his last employment.
I just want to qualify your point because for me it's at least very important, is you're distinguishing between something falling within the scope of the Act versus there being some operative procedural bar to him pursuing the claim.
Right. The bar that prevents him from proceeding the claim, from pursuing the claim, is the 4-year limitation.
Which you view as a substantive part of the agreement that the Act would only cover claims that manifest within 4 years of the date of last employment.
Yes.
And the General Assembly did not intend the grand bargain to include claims that manifest beyond 4 years.
No, just like the General Assembly did not include the grand bargain to include the types of claims that were brought in Greer or Lord, which were not occupational diseases as defined by the Occupational Disease Act. So that's another, is mesothelioma an occupational disease under the Occupational Disease Act? Most likely. There's been no determination here, and that's all set forth in our brief, so I don't want to belabor that point. But Greer and Lord did consider that, and they did come to the conclusion that if they're not occupational diseases as defined by the Act, then a civil case can go forward because you're not within the coverage of the Act. Similarly here, because we're outside 4 years, we're not within the coverage of the Act, so we can go forward with a civil case.
That's a factual question, though, isn't it, on which counsel disagree?
I think if you're looking at the date of last employment between the date of diagnosis, perhaps it's a factual question. Well, really, it's a legal question, how you're going to interpret employment versus exposure. But I don't think you need to do that here because the Occupational Disease Act does not speak to date of diagnosis. It speaks to date of compensable disability or death. He died more than 4 years after his date of last employment.
Why is it relevant at all? I mean,
I don't think it is.
Right? I mean, you said it's a problem, and let's assume that everybody here agrees it's a problem. The big question is it a problem that we're supposed to fix or that we can fix? Or if it's a problem, is it a problem the General Assembly has to fix?
No, I think clearly it's just a simple matter of statutory interpretation. And even if you look at employment,
then it's no problem. You said it's a problem. It's no problem then.
I don't remember what I said was a problem. I don't see it as a problem. No, I don't see it as a problem in this case because he died more than 4 years after date of last employment, and he was never economically disabled. And so we don't have the 4-year issue. We only have the 4-year issue if you're going from date of diagnosis. And because date of diagnosis is not in the Act in any way, shape, or form as a triggering thing, we don't even have to worry about it. We're outside 4 years regardless, no matter how you interpret employment or exposure. I think it should be interpreted as exposure. I think that's consistent with every case that's interpreted the two terms. But
Well,
even
the
if you,
statutory language, though, as Justice Brobson mentioned, doesn't say that. It says employment.
true, but ODA cases have taken a look at the statutory language and says in his employment in such occupation or industry, and I would proffer that Mr. Herold had an occupation of stationary engineer until 2014 where he was exposed. Then he changed occupations and became a foreman, and then he had no further exposures.
Okay, we'll sort it out. Any other questions? That was well argued by both of you. Thank you
Thank
so
you very
much.
much.
Mr. Minner, we're going to take a lunch break. We can resume at 1:30. Good afternoon. In this appeal, would you call the next case before I describe it?
We're anxious.
Donegal Township et al. Versus Richard Martin Jr. et al. Representing appellants, Mr. Alexander Brown, representing Kelly, Mr. Thomas King III.
Thank you, Mr. Minner. In this appeal by allowance, we must determine whether Section 402E of the Second-Class Township Code, which provides second-class townships with the ability to permit voters to alter the number of township supervisors by way of a referendum vote, is unconstitutional as applied to 2 township supervisors whose terms in office were cut short when the voters opted to reduce the number of township supervisors from 5 to 3. Please proceed.
May it please the Court, Madam Chief Justice, opposing counsel, I'm Attorney Alex Brown from Meyer-Dara, representing the appellants, Donegal Township, James Bauer, Randy Poland, Edward Single Jr., and Kathleen Croft. Not in person, but joining me in this case figuratively would be my co-counsel Bernard Matthews and Charles D'Angelo.
Thank you.
Your Honor, the Court should reverse the Commonwealth Court's decision that Section 402E of the Second-Class Township Code is unconstitutional as applied when the number of township supervisors is reduced by referendum from 5 to 3, causing the abolition of supervisor seats in that municipality. Martin and Fiddler, the Aplts, have a heavy burden of persuasion to prove that the statute is unconstitutional, and they cannot meet that burden because they have failed to show that Section 402E clearly, palpably, and plainly violates the Pennsylvania Constitution. There are 2 primary reasons why this argument by the Aplts must fail. First of all, public officials in legislative offices can be lawfully ousted from their offices before their term concludes if their offices are abolished by referendum. And so going into that principle, which this court has actually upheld for over 150 years, since the 1860s, this court has long recognized in the McCombs case, not having been mentioned by the Constitution, the legislature was left with unrestricted power to prescribe what the duties of the office should be. And this is referring to legislative offices. Having the power to create, they have also the power to regulate and even destroy. So under the Constitution, particularly Article 6, Section 1, there's a delineation between offices that are explicitly mentioned in our state's Constitution, which are known as constitutional offices, and then legislative offices, which are all those offices which the General Assembly has general power to create in terms of local government of our people. And the court has very often reaffirmed this principle, not only in McCombs, but in the 1890s in Weir. The power which created legislative offices may abolish or change them at pleasure without impinging upon any constitutional right of the possessor of the office.
What about a different framing? Is it necessarily only about the right of that person, or is there a right that resides in the voters? And what I mean by that is, regardless of what we held in the past, going forward, should we interpret our Constitution to recognize that the voters in election X cannot have their will superseded by the voters in that same township in a subsequent election? Follow my question?
I do, Your Honor, and the court should not so hold. The court has to look at the most recent election in which a referendum was proposed to determine essentially what type of government or what number of supervisors in a particular municipality applies. And so in this situation, there was a referendum in 2020 in Donegal Township which decreased the number of supervisors from 5 to 3, and that would become applicable on the first Monday of January 2022, which is immediately following the 2021 municipal election. In that election, there was a decision by the voters to elect 3 supervisors in Donegal Township, with the highest vote getter getting a 6-year term, second highest vote getter getting a 4-year term, and the third highest vote getter receiving a 2-year term. And looking at the language of Section 402E in the second-class Township Code is critical in determining why this is an abolishment of an office as opposed to a removal of a specific office holder from an office that's going to continue to exist. That statute states, in part, 3 supervisors shall be elected to serve from the first Monday of January after the election, when the terms of the officers of the 5-member Board of Supervisors shall cease. The terms are cut off, which is consistent in the language of 402E with the decisions of this court that have spanned the last 150 years. So this is a situation where there was an opportunity not just for the sitting supervisors on the 5-member board in Donegal Township, Washington County, but any other eligible elector for that office to seek a seat, one of the 3 seats on the new Board of Supervisors, which is going to come into power in early 2022.
Which was a new form of government, would you say that?
Your Honor, I would not concede that point, although, and the reason I say that, and I should be careful how I frame this, is because there is no prerequisite under Pennsylvania law for there to be a new form of government in order for an abolishment of a specific office, a specific position, or a specific government, and the office holders in that government from being replaced.
But it does sound like, I'm sorry, it does sound like a change in the form of government if you have a government that is run by 5 supervisors versus 3.
And, Your Honor, that is our secondary point in our case. We argue that neither the trial court nor the Commonwealth court had to get to the issue of whether there was a change in the form of government to recognize.
Let's probe that.
Sure.
Change of government. All they've done is reduce the number of supervisors. The supervisors maintain the authority similar to the 5. Do not these 3?
They do have similar legal duties, Your Honor.
402E requires an abolishing of the unit, of the government unit. Abolishing means a total eradication, going from commissioners to home rule. Share with me how reducing the number of supervisors is abolishing a form of government as opposed to reducing for purposes of financial stability, hypothetically.
Well, it would be a change in the form of government because of the significant difference between what type of or what number of people would be needed to constitute a quorum, what number of people would be necessary to transact business in that particular context, and in addition, other provisions of our Constitution indicate that there is, under Pennsylvania law, a requirement under, I believe this would be, and I'll just make sure I have this citation correct, under Article 9, Section 3 of our Constitution, the General Assembly has to provide optional forms of government for all municipalities. Adoption or repeal of an optional form of government shall be by referendum. And so what's interesting is that the constitutional language parallels this idea of a change in the form of government in that there is a referendum necessary in Donegal Township in 2016 to go from 3 supervisors, which is the default rule under the second-class Township Code, and then to a 5-member Board of Supervisors. And the same thing in 2020. Whenever the voters of Donegal Township decided to place a referendum on the ballot and then approve that referendum to go from 5 supervisors to 3, that tracks essentially the language in the Constitution, Article 9, Section 3, that there was an optional form of government that the legislature provided in that there's the default 3-member Board of Supervisors, which could be enhanced or altered to become a 5-member Board of Supervisors, and that then could be replaced back to a 3-member board. But all of those decisions are by referendum, which is consistent with the requirements in the text of the Pennsylvania Constitution.
So are we saying that because they were reducing the number of supervisors, that upon the retention date of each supervisor, one could not be replaced, and the last 2 just after they serve their duty be liquidated or removed from that position? That would be more of an abolishment.
Well, I would say, Your Honor, just based on the language of 402E, this actually isn't targeted to any particular supervisors. It's actually an action that affects all 5 supervisors, and so all of their terms are curtailed. And so at that point, there becomes an opportunity for any eligible voter or the incumbents on the 5-member board to seek a new term. And what's interesting about that is that the Aplts in this case, Mr. Martin and Mr. Fiddler, they could have, if they would have won in that 2021 election to the 3-member board, could have actually obtained terms that were longer than what they were operating under the 5-member board. And so this is a situation where the entire 5-member board is abolished and a new 3-member board, which is the default rule under the second-class township code, applies.
Can I just dicker real quickly with the abolishment thing? If I read the statute, I'm not sure I believe that their offices were abolished. It seems to me the statute specifically says their terms end, not that an office was abolished. So it takes whatever their term was and it truncates it, and they served out the term of their office. They were not removed. Their offices were not abolished. The General Assembly said, this is your term. You were elected to an initial term, but when they ran, that same provision that said the term is, it's sort of qualified. By the way, because the municipality can pass a referendum and basically reduce your term. So they were not removed from office. They fulfilled their office.
That's correct, Your Honor, and I think that's a fair interpretation, whether we classify it as an abolishment, whether we classify it as the legislature reserving a right in the people of Donegal Township to eventually cut off the terms of the 5-member board.
Reduce it.
Reduce it,
Reduce
yes.
it, and they've served their term, and they're done.
Correct, and there's no office, on whether you call it an abolishment, whether you call it a cessation in office or a curtailing of the term, an ending of the term, ultimately all 5 of these supervisors that were elected and that were present towards the end or until the end of 2021, all of them essentially could not be removed from an office because the offices no longer exist. And that's a point that I try to make in a pithy fashion. One cannot be removed from an office that no longer exists. And so that's why this case doesn't fall under this court's precedent in South Newton Township or its precedent in Reese, simply because those cases involved specific attempts, specific targeted electoral attacks on particular elected officials for perceived poor performance or inadequate performance of their duties. And so that's whenever the impeachment provision of the Constitution would come into play, and that would be Article 6, Section 7. And that does provide a condition for all elected officials that they behave well in office. And if they violate that provision, then it's up to the governor upon good cause and the legislature, particularly the Senate, with a 2/3 majority, to agree to remove that particular office holder. And that's what essentially was bypassed in South Newton Township and what was bypassed in Reese. There was a specific constitutional provision that prohibited the second-class township code or a home rule charter or any other form of government from effectively allowing for a specific elected official to simply be recalled or specifically terminated.
Counsel, could I ask you a question about that? Do you agree that these people are civil officers within the meaning of Article 6, Section 7?
I do, Your Honor.
And do you I take it you disagree with any argument which would say because that provision of our Constitution speaks to the removal of such officers for misbehavior in office, that there's not the opposing implication that such civil officers are entitled to serve out the term for which they've been elected absent such misbehavior, and that would be of constitutional dimension.
So the Constitution never speaks to an entitlement of any particular elected official to serve out the entire term of their office. Whenever an individual is a legislative office holder as opposed to a constitutional office holder, they are subject to removal either through an impeachment proceeding, which would be raised up to the governor level and the Senate, and then alternatively you would have this abolishment pathway or the cessation of term pathway, which would be within the power of the legislature to define. But the difference between this situation as opposed to what we saw from this court in Erie and South Newton Township is that here we have an entire governmental apparatus, all of the elected officers being essentially in one fell swoop cut off from their terms, whereas in the Article 6, Section 7 context, it's a targeted proceeding for specific misbehavior or alleged improprieties in office, which would essentially cause that proceeding to occur.
Counsel?
Sure.
I think your statutory argument and your argument from precedent, those are both strong. I'm just stepping back and asking you if you don't have any concern that there's a negative implication from the removal provision for misbehavior as to civil officers, which could suggest that absent such misbehavior, such civil officers, as a constitutional matter, hold their office, and that then there might be an argument that would, and I realize I'm jumping another chasm here, I'm just venturing this idea, whether that might carry with it the implication that they get to do that for the rest of their elected term.
Your Honor, to more directly answer your question, no, there is no negative implication, because if such an implication were to exist, then many things, many provisions essentially could be added to our Constitution without the consent of the people or our state legislative branches. So that would be a bypass of the will of the people, and effectively it would be writing into the Constitution protection for specific elected officials that does not exist in the Constitution and has not been set forth in any sort of operative legislation by the General Assembly. And so the case law has always held that no one has a right to a public office. Anyone who's elected into a public office can't have that office's terms changed. It can have their, their, not just their terms, but effectively the office itself could, at a moment's notice, be taken away by an act of the legislature. There could be a massive restructuring at any given time of the...
Unless they're constitutional offices.
That's correct, Your Honor. That's the major distinction, is between the constitutional officers and the legislative officers, which are basically any elected officials that aren't mentioned explicitly in our Constitution. And so that's why, for the 5 supervisors that were present on Donegal Township's board in 2021 and prior to that, that's why their offices can be cut off in the harsh manner that it was. But the beautiful saving grace is that there was still a political opportunity for all of them to seek elected office on the new 3-member board or anyone else in Donegal Township who was eligible. And so...
And they did.
And they absolutely did, Your Honor.
Lost.
They absolutely did. They absolutely did. And so the will of the people was completely effectuated in Donegal Township. They wanted to reduce the size of their government. They did, and they picked the 3 folks going forward that they felt most comfortable running their municipality. And so this is a situation where they do not have a right to serve out the remainder of their terms. Life has to move on. And in fact, there's only one out of the 2 Aplts at this time, and that would be Mr. Fiddler, who would have essentially a right that he could argue before this court because his term was supposed to go through 2026. And so with the passage of time, the difficulty in addressing this matter in any sort of practical fashion as to somehow putting Mr. Fiddler back into office becomes more and more difficult. And that's just another reason why, beyond the constitutional provisions, beyond the case law, and beyond the text of the Section 402E in the second-class Township Code, for why the Commonwealth Court has to be reversed. If your honors have no further questions, I will just simply ask for reversal, and I thank you for your time.
Thank you, Mr. Brown. Let's hear from Mr. King. Mr. King, I'm used to seeing you here on much higher profile matters.
Well, it's nice to see you, Your Honor. May it please the court, Madam Chief Justice and members of the court. It's my honor to be here. I wanted to introduce, if I might, Sophia Benoit, who is a member of our firm who worked on the brief in this case, a recent graduate of the University of Pittsburgh Law School and a new member of this bar. So I'm honored to bring her here today. This is an interesting case. Mr. Brown gave a good recitation of the facts to a certain extent. I don't agree completely with those facts. Mr. Justice Doherty asked the right question, and I'll get to that in a minute. What happened here is essentially you had 3 township supervisors in Donegal Township, Washington County. In 2016, there was a referendum, and they went to 5. Then they went from 5 back to 3 in 2020. So you have 3 to 5 to 3. And in doing so, 2 people were actually put out of office. The 2 people, to answer Justice Brobson's suggestion earlier, 2 people actually lost their seats, Mr. Fiddler and Mr. Martin. And Mr. Brown is correct here. Mr. Martin, because of the time that's gone by in pursuing this case, Mr. Martin was, his term actually expired in January of this year. So the one person that remains is Mr. Fiddler. Fiddler's term would expire in 2026. So it's still a live case here before the court today. The Constitution provides quite clearly at Article 6, Section 7, that, and this is Mr. Justice Wecht asked this question, are these people civil officers? And I believe the answer was yes, and my answer would be yes as well. These people are civil officers, and the Pennsylvania Constitution clearly provides that the removal of civil officers is on the condition that they behave themselves well in office. I won't read the whole thing. You're all familiar with it. And so, in essence, to remove someone from an elected office, you have to be impeached. And it's not just that the Senate is somehow involved. There has to be an impeachment, and the Senate has to, by 2/3 vote, impeach you. What I would suggest to the court is that this singular issue case is very important. The Constitution of Pennsylvania does not provide for recall. We don't have what they have in California and some other states. We don't have a recall. You can't recall the governor, as you could do in California. You can't recall these supervisors, for example.
Could I interject? I think that's all clearly correct that we don't have California's recall.
Yes, sir.
Thank goodness.
Yes, sir.
Chaotic. But we also don't have good beaches like California. Anyway, on that Article 6, Section 7 argument.
Yes.
Why is that the provision that's germane here rather than Article 9, Section 3? Doesn't Article 9, Section 3 indicate that the framers gave the municipalities the chance to do just this, what happened here? So that, in other words, aren't you putting the rabbit in the hat by presuming that these folks were ever removed to begin with? Isn't it rather that the optional form of government provision was invoked?
Well, I would answer your question, Your Honor, in this way. This is not a change in government. This is the second-class township code, and Judge Covey wrote an excellent opinion in this case, in which the 3-judge panel in the Commonwealth Court were unanimous. In Judge Covey's opinion, she cites to Section 601, I believe it is, of the second-class township code. In Section 601 of the second-class township code, the provision is that the legislature has set up this scheme, to answer your question, that townships have to be governed by supervisors. And the scheme is that you can either have 3 or you can have 5. So if I have 5 fingers and I take away 2, I've still got 3 fingers. These, and I don't mean to be cute about that, but the point is that these people were supervisors, and this is, I think, what Mr. Justice Doherty was asking earlier. These people were supervisors when they were elected, and they were supervisors when they were removed. The problem is they were removed by a method that is unconstitutional because it violates Article 6, Section 7.
But that's that's just my question is, were they removed, or was it instead that by mandate of the voters of that township that the system changed, that they went from 5 to 3?
And to answer your question, my opinion is that they were removed. They were supervisors one day and the next day they weren't. They were supervisors making supervisors' decisions. They were signing checks. They were buying equipment. They were overseeing the operation of the township. One day they were, and the next day they weren't.
Counsel,
it wasn't.
If that's the case, then why didn't your clients prospectively file suit to prevent the referendum? Because obviously we went from a 5 to a 3. The referendum basically crammed down government from 5 to 3. If your clients knew that going in, why did they stand for election as opposed to seeking a stay and then challenging the constitutionality? In other words, why wait until they lose the election and then complain about it?
I would be speculating, Your Honor. The only thing I could say is that I presume that they were willing to engage in the process and try and see if they won the election. But they nonetheless they did file twice, and they did file while they were still in office. I wanted to point out to you, though, that in the Reese case, which Judge Covey correctly recites, because Reese and Bouch are the cases that control this case, in my opinion. And in the Reese case, this is what Mr. Justice Aplt said, the former Chief Justice. Article 6, Section 7 of the Pennsylvania Constitution indisputably applies to all elected officers and sets forth in unambiguous language the exclusive method, absent impeachment, conviction of crime, or misbehavior in office, of removing such elected officers. The exceptions that are cited by the appellants in this case are different. These are cases where there was a change in the form of government, where somebody did, and by the way, I believe that constitutional provisions about alternate forms of government, I think we're talking about the charters, charter cities, charter counties, etc., where they create a charter. This isn't an alternate form of government. This is the same form of government. There's simply 5 people one time and there's 3 people another. They all have the same title. They all perform the same jobs, and that's why Judge Covey is correct.
Counsel, if I may ask you.
Yes, sir.
Applying constitutional Article 6, 7 along with 9.3.
Yes.
Would your argument be different if, based upon the referendum, the 3 were elected and the first 2 would replace the first 2 up for retention or re-election, such that when the first one who was out in 24, he would have stepped aside, he would have had his opportunity to win the seat under the 3, he lost, and then in 26, the second winner would have replaced them. Would that have been constitutional?
That's a very complicated scenario.
It seems to be applying the constitutional principles together if you read them in parliamentarian.
Yeah, had that occurred, had they won these seats, they wouldn't have missed a beat. You know, they wouldn't have gone from one day to the other. They would have been supervisors and supervisors. So we may not have had a case at that point. But they did not win, as was pointed out earlier.
What is the relief you're seeking? To be reinstalled as a supervisor, or are you looking for money damages?
Oh no, we're not looking for money. We're asking several things. One of which is to declare that the election of the 5 was invalid and void ab initio. We're asking that we asked that Mr. Martin and Mr. Fidler, but Mr. Martin's term has now expired. We ask that Mr. Fidler be reinstated and that the court declare, and these things are not before the Supreme Court right now, they have to go back to Washington County. We ask that the court declare that election that took place was invalid because the section that it took place under is unconstitutional. And so we would ask that Mr. Fidler be reinstated as a supervisor. He was, Mr. Justice Robson, you asked the question about were they out of office. I think you asked that. The answer is they are. They were in office one day. They're out of office the next day.
Well,
they were removed.
That's so, you know, and I may be approaching this a little bit differently, but, you know, I view Article 6, Section 7 as a removal of office. You're in your term and you're removed, creating an unexpired term that probably has to be filled by appointment or something like that.
Well, they were in their term.
Well, I know that's your argument, but your clients ran under this statute. This statute, your clients took advantage of the referendum process in this statute to expand from 3 to 5, right?
Yes.
Okay. So they took advantage of that. They ran. They became the additional supervisors. But now your clients are claiming, well, only part of that statute applies. We get the full 4 or 6 year term or whatever it is, notwithstanding the fact that there's another provision in there that says, but you get those terms, but if another referendum is passed, your term, if you don't win, will end on the whatever it is, the January, it's not the next day. They weren't removed in the middle of the term. Your term will now end on this day. So the whole scheme your clients took advantage of to even get into office contemplated a conditional term of office that would then be truncated by a subsequent referendum. And now you're saying, oh, but that's all unconstitutional. I'm having a problem with that.
I appreciate that. So what I would say to your honor is this: that idea of a conditional election has been dealt with by this court on at least 2 occasions, in Bouch and in Reach both. And in those instances, the court has said there is no such thing as a conditional.
Were both of those involving a statute that specifically said if X happens, your term goes from 6 years to?
They're not the same as this. They're not on the same facts as this case.
Those were premature interruptions of a term of office.
And this was too, Your Honor. With
well,
all due
I think
respect.
that's where I'm going to have to. That's where I'm wrestling. Was this a removal contemplated by the Constitution such that there was an unexpired term, or was it simply a act consistent with the General Assembly and the people that says if the people do this, the term is Y, not X?
I think the answer to your question is this, at least from my perspective. If this method of removal is upheld, it's my opinion that this will create recall in the Commonwealth of Pennsylvania for the first time ever. We don't have recall. It's not constitutional. And you can create recall by the imposition of this section of the second-class Township Code. Judge Covey's opinion talks about recall, and she's right. This is what this is. This is a recall section that conflicts directly with the Pennsylvania Constitution. We don't have it. I don't think we want it. And I think that this will have implications, at least across, most of the townships in this Commonwealth are second-class townships, right? Across the whole state of Pennsylvania, there are thousands of second-class townships. This is a method by which someone can undertake with a very small percentage, it only takes 5% of the voters, I think, is the statute, to put this on the ballot, change from 3 to 5, and then reduce from 5 to 3 and get rid of whoever you want to get rid of. The voters, when this...
You can't get rid of whoever you want to get rid of because the voters do that. So recall is specifically related to one individual. In other words, someone wants to recall Justice McCaffrey as a justice elected to the Supreme Court.
They can't do that, Justice.
Correct, they can't. So the fact of the matter is this. In this particular case, you're not talking about a recall specifically directed at one person. You're talking about the change of the government from 5 to 3, and they have the opportunity to stand. So the voters get to decide who those 3 individuals are, which kind of relates back to my earlier question. If they really felt it was unconstitutional, why didn't they challenge it before the election?
I can't answer that question specifically. I don't know exactly why they did what they did, but I can answer it this way, and I mean this respectfully. Regardless of whether they challenged it then or not, they challenged it subsequently. And a constitutional challenge is, of course, the principle is that there's no such thing as laches, there's no such thing as waiver. If it violates the Constitution, it violates the Constitution, and so they're entitled to bring it when they brought it. But I understand your question and your point, but what they did here was bring this because they were removed from office.
Counsel,
yes, ma'am.
Can I ask you to address opposing counsel's rather straightforward argument? He's relying on a line of cases that go back to 1867, starting with McCombs, Weir, Moore, Ritchie versus Philadelphia. Why is he wrong? I mean, those cases seem fairly clear-cut in their mandate regarding this issue?
Because he ignored the cases that are subsequent. The Justice Cappy's case, Justice Apelt's case, their decisions in Bouch and in Reese, and in fact, the Reese case overturned this 1926 decision of the Supreme Court that might have gone the other way.
But none of those cases overruled the line of cases that your opposing counsel is relying on under Article 1, Section 1. I mean, as recently as 1985, in reapportionment of the school district of Pittsburgh, follows that same principle. If the legislature creates an office, the legislature can abolish the office.
That's, in my opinion, Your Honor, I believe what that line of cases are talking about. There's the business of changing the form of government. There's also the creation by the legislature of things like boards. For example, the Pittsburgh School District case is a case where you had a school board and you had it elected. I'm not sure it was elected at large and they went to districts, or that were districts and they went to at large. So those are the line of cases they're talking about. They're talking about changes in the form of government. They're talking about boards, for example, legislatively created.
These are not changes in the form of government.
Right.
These are doing away with certain positions within the government.
Yes. And
once again, why is that not applicable in the circumstances that we're dealing with here?
Because that's not what happened here. What happened here is you had 5 supervisors, you went to 3. You still had supervisors. We didn't change the form of government. We didn't change the...
That's a different consideration. Forget about a change of government. This is... there is a creation of the offices for 5 supervisors, and just for the sake of our discussion, 3 undesignated of those offices was abolished. Why is that not permissible?
It's not permissible because it flies in the face of the Pennsylvania Constitution that for removal of civil officers. These are civil officers. These are people who were elected, and they can't be...
But that provision deals with essentially misbehavior in office. I mean,
I believe it's for whatever. If you want to remove these people, you want to remove an elected official, you look to Article 6, Section 7, and they need to be impeached. I mean, that's a fundamental principle that is at stake in this.
How do you know the voters wanted to remove these people? How do you know the voters didn't just want to go from 5 to 3? I mean, you're conflating the referendum option of going from 5 to 3, which had nothing to do with individual people, to the election that your clients willingly participated in and lost.
Well, we're not challenging challenging facially the statute. We're challenging the application of the statute to the circumstances of this case. So we're challenging constitutional applicability.
If the statute specifically says that the terms of the 5 members expire or end,
yes,
on the January following the election of the 3 new, give me an example of how it could constitutionally be applied.
These people were elected to specific terms of office, just like
so only if they see, that's where it breaks down for me again. You're saying that the referendum part could be constitutional only if they win?
Well, no. What's happening here is you've got this section of the second-class Township Code, and you have Fiddler and Martin are both elected, right? And so they're elected to a term of office. How can Fiddler and Martin be removed under Pennsylvania law, under the Pennsylvania Constitution? The only way that Fiddler and Martin can be removed is under Article 6, Section 7, and that's to impeach them.
But
they're elected to a...
This is an you said it. You brought up as applied.
Yes, sir.
So I'm trying to figure out. For it to be as applied, it means that it can be constitutional under some circumstance. Give me a circumstance where there is a referendum that reduces from 5 to 3, and there is no unconstitutional removal from office.
Someone doesn't challenge it. Someone doesn't remove. Someone decides not to run.
Or they complete their terms before it takes effect. Would that be possible?
Yes.
If the sitting supervisors completed their terms before the new form took
Yes,
place.
Your Honor, and that's actually the case here where there were 5 supervisors, and if you look at Judge Covey's opinion, you'll see that some of those supervisors, their terms naturally expired. And so there's no constitutional issue there. It's there were 3. There was another supervisor, but he ran and won. So he's obviously not going to challenge this. But these 2 gentlemen ran for a term certain. They were elected for a term certain by the voters who showed up in 2020 and elected them.
And your view is they didn't elect him knowing under 40, and your clients didn't run knowing under 402E that there could be a subsequent referendum that would cut their term short. The voters took that not at all into the calculus, and your clients took that not at all into the calculus.
I can't speak, Your Honor, for the voters, but I can only say that with...
Well, you're saying the voters elected them to a 6-year term, but in that same statute, it's a 6-year subject to a reduction if the voters subsequently pass a referendum.
I don't think so, because we don't believe that they could reduce it. We don't believe that that's possible. So I don't believe that either Fiddler or Martin believed that that could happen, because I don't think either one of them believed that anything could happen under Article 6, Section 7 of this Constitution, that the only way they could be removed from office would be misbehavior or a commission of a serious crime. So that's the only way they could be removed. This case has implications beyond the second-class township code, so it's important. This issue has been revisited by this court on a number of occasions, so I think it's important, and that's why I think Judge Covey and the 3-judge panel in the Commonwealth Court got it absolutely correct, and that's our position.
Thank you. Are there any further questions?
Thank you very much.
Brown, thank you very much. Well argued.
Yes, ma'am.
Good luck with your legal career.
Commonwealth of Pennsylvania versus Michael L. Strunk, representing Mrs. Strunk, Mr. Spencer Bradley, representing Commonwealth, Mr. Brian Lysing.
In this appeal by allowance, we have been asked to determine what constitutes contact for the purposes of the offense of unlawful contact with a minor, and more specifically, whether evidence is sufficient to sustain a conviction for unlawful contact with a minor where the complainant testified that the sole verbal contact occurred after the underlying sexual assault ended. Please proceed.
Thank you, Madam Chief Justice, and may it please the court. My name is Spencer Bradley. As most of you are aware, I am affiliated with the Dauphin County Public Defender's Office. It is a pleasure to be back in Pittsburgh after being away. I'm from the area, so I'm pretty happy to be back here. This is a case dealing with a couple things that are unseemly, that are abhorrent, but the clear legal question here is a very simple one. Sometimes an assault is, as abhorrent as it is, just an assault. In this case, the record demonstrates that throughout the 3 incidences of sexual assault that Mr. Strunk engaged in, there was no communication. There was no statement made by Mr. Strunk to the complainant. There was no ongoing discussions between the complainant and Mr. Strunk about these assaults. They occurred.
Does it require verbal communication to qualify as contact?
So, no, Your Honor, and I think that takes me to the text of the statute, the plain text of the statute. The statute contemplates communication or contact, and I think the position here, I think where the parties and where I fault the Superior Court opinion below is contact and communication. It's disjunctive. We've dealt with that a lot today. It's a disjunctive, but whenever we read statutes, and I don't want to bring the legislative history into it quite yet because we don't need to, but we deal with statutes by their neighbors. We know what these terms should mean by the way it's used within the statute. If the legislature simply meant contact, leaving it open, well, when I write a letter, that's a contact, but what's within that letter is communication. The communication, what I'm saying to whomever that letter is meant for.
What if I don't receive the letter? Has contact been made?
In that hypothetical, well, let me answer your question with a question. Within the context of
Can't do that.
within the context of unlawful contact, if a defendant, say, we'll use an uncle example. If an uncle was sending letters to their niece attempting to start a sexual relationship, right? But unbeknownst to everyone, the niece and her family had moved to a separate apartment unit, new home, whatever, and there hadn't been contact made, that still would be criminalized because there had been that,
Contact was initiated.
Correct. It is the messaging, not the message. And that's the distinction that within the plain text of the statute, I would offer. That's what the specialized definition of contacts requires. This isn't I don't want to use the word lay definition, but I'm going to. This isn't a basic definition of contact. This isn't something like contact football, or I contact you when I punch you. My fist comes into contact with someone. The definition of contact by the company it's keeping within the definition of contacts by the statute is contextualized. It's like and like. It requires these things to be similar by canons of statutory construction. And not to, gild the lily by way of this argument, but this was what was understood when the legislature passed this particular offense, because we were dealing with a society that was rapidly accelerating the methods in which sexual abuse of children can occur.
Well, counsel, wasn't that, I assume that's exactly why you wanted to kind of avoid the legislative history discussion. Because the legislative history discussion, if you've taken a look at it, this particular statute was actually enacted for the specific purpose of criminalizing inducement, not contact, not physical contact. Have you looked at the legislative history?
I have, Your Honor, and that's why I was a little puzzled there, because I think the legislative history actually is supportive of my interpretation of the statute, which would be it's solving the problem of inducing minors to, be groomed, to be victimized, to lure children.
You have to communicate with them in order to put them in a position where you can physically contact them. That's the purpose of the statute, right?
Correct. And I think the problem here, at least in the reasoning of the Superior Court opinion, and this is,
How do you reconcile that with the fact that in this particular case, the only contact was an unconscious child and physical contact with them? There was no inducement, there was no phone call, there was no email, there was no, hey, come into my bedroom.
He's representing the
but I'm asking to induce the differences. I mean, how do you...
I would agree. My position is this is not unlawful contact. It just isn't. There's no communicative element. It's an assault. It's a sexual assault.
Wasn't your client's position at trial that he admitted sexual contact with the victim, but claimed the first time he mistaken the victim for the victim's mother, and in the second and third instances they were consensual? So don't you have to have some type of communication in order for there to be consent?
Well, I think therein lies the distinction between the types of claims being raised. If we were challenging sufficiency on the basis that...
How do you come to a consent without some type of communication? That's the question I want you to answer for me.
I would say, quite frankly, for purposes of this appeal, clearly the jury rejected that, so I have to, in order to challenge any of this, accept the jury's rejection of that potential defense.
Whether the jury rejected or accepted that there was, it was your client's position that the second and the third contact with this victim was consensual.
Well, if it was consensual, then we wouldn't have unlawful contact. I mean, there would be, if it's consensual sex and she was, above the requisite age, which she was during the time period of these offenses, I believe she was 17 at that time, she was capable of having a consensual relationship with him, were that to be true. I wouldn't approve of it, but she could. I think the, issue here is the record below, the facts of the case for each incident. Incident 1, fondle, pull down pants, there's penetration. Incident 2, came into the room, digital penetration. Incident 3, enter the room, got into bed, began having sex. In each of those 3 incidences, there's no communicative element unless we wish to say a rape in and of itself has communication within it, which would present a merger issue because now the act that is functioning for contact is now contact. I think the problem with this case is, simply put, the reasoning of the lower court, particularly the Superior Court, but in its rejection of post-sentence motions and motions for judgment of acquittal. The thought process of the lower courts was, well, the pulling down the pants to initiate the assault, that's copacetic, that's contact. And the language of the statute simply, it's stretching that language of the statute, the communicative context of the words within the statute that define contacts, it's stretching it too far.
Counsel, if the statute talks a little bit more, if it's not focusing on contact or communication for a minute, it talks about contact or communication in furtherance of crimes
yes.
that are enumerated.
Correct.
Right?
With you so far.
Okay. In a scenario where an adult, let's take an adult. I understand juveniles could engage in this activity as well, but let's just, for the sake of a hypothetical adult, walks into a room, walks behind a young child, and pulls the child's pants down, including underwear, and the child runs away, screams and runs away. Does that constitute an indecent assault?
Would that constitute an indecent assault? I might be slicing it very thin based off of this court's Gamby decision, but I would still say yes. We could quibble about where exactly the pants are being pulled down, but I'd probably say yes. I'm willing to go that.
Well, let's assume it was for purposes of sexual gratification, and it wasn't for some other lawful purpose.
Right, and I'm with you. So yes, I'll concede that point.
Okay, so would you believe that would be chargeable as an indecent assault?
Correct.
Okay. If that is chargeable as an indecent assault, what's the difference then the act of pulling down the pants for this juvenile was also an indecent assault and, under the prosecutor's theory, unlawful communication?
I would say both would fail to constitute unlawful communication for 2 reasons. And I think
well, it can't be both, though. That's your argument, right? The act of pulling down the pants in a non-legally justifiable, under the circumstances that I presented, and the circumstances here,
right.
Can't both be an act in furtherance of indecent assault and the same indecent assault, right? That's just your merger argument.
Right. I'm catching up to where you were, Your Honor, so I apologize. I would say in that instance, if the sole action that is,
if the act itself that is claimed to be the communication or contact is the indecent assault or is an indecent assault, can it ever also be a separate communication or contact for purposes of inducing an indecent assault? Can it be both?
If I understand your question correctly, and it's a couple moving parts, so I do apologize if I'm not keeping pace, is if there is the indecent assault, can there also still be unlawful contact for the purpose of inducing?
Can they be one and the same? Can the communication and contact also be an indecent assault?
I think the question is, or at least I'm understanding it, can you have the act of touching the underwear or the pajama pants to be both a precondition of the actual sexual assault as well as the communication necessary to meet the element?
I think if you
what he said.
Yeah, I'll answer both. I think in that particular instance, when you have a completed predicate offense and there is not sort of tertiary factual scenarios, they would have to be one and the same. And by way of example, to Justice Brobson's question, If there are facts within the record that come out during trial that there's been leering or, the defendant
I didn't include
says...
leering in my hypothetical. My hypothetical was simply the act of pulling down, touching the underwear, as Justice Doherty said.
Right, and
pulling down the pants. That's all I'm talking about.
And my answer to that would be, once it is the precondition and there's nothing else there, unlawful contact cannot be substantiated because that's a precondition to a larger offense.
Counsel,
That's your whole argument. I don't know why you're hesitating in answering that question.
Because I think I'm having issues keeping up with the question phrase.
I guess the question that I have, my concern is that if it becomes a precondition and a contact, then we have just per se put anytime a child's involved, we have now per se struck them with an unlawful contact.
And that's the issue.
That's why I don't know why you're hesitating to answer this, because what Justice Doherty just said is your entire argument.
It is, and I think I was just misunderstanding the question.
One's a completed act, the other's in contact or in furtherance of the act. That's what Justice Doherty's pointing at. You understand the distinction there?
Yes, I do, and that's the entire distinction here. Is in this case, all you had was the completed act. If unlawful contact is meant to have a communicative element to it, there was no communication here, period, other than...
So there's no completed act?
No, there was a completed act, but there's not a communicative element to this entire affair. There's just the act. An assault is just an assault. A sexual assault occurred. There doesn't need to be a panoply of, well, there was actual communicative element here. It just was. It's abhorrent, but it just was. If there were other facts within this record, or as I concede...
Like example, he consented, she consented?
And I push back on that because if the theory of that case was consent, then there's no criminal intent there. It's a consensual sexual relationship. I think in candor, these particular types of factual scenarios where it's a family member, where there is a individual within the family dynamic and it's sort of continual abuse, whether staying in the home continues to be, a larger communicative element to maybe, open the pathways back up to continue to reoffend, that's a different question. And if on and if the court were to, leave that as an open question for this, the lower courts to address, we may very well lose that particular theory of it. But as the Superior Court held, the only contact was the acts that needed to happen for there to be the underlying sexual assault. And I'm saying contact in the sense of like physical touching.
Counsel, that's my point. You're viewing the taking down the pants as a predicate act to engaging in the criminal activity. Isn't the taking down the pants itself a criminal activity, even in the absence of the communication and contact?
Yeah, it'd be a different offense in which he could be held liable for.
Right.
So I don't see any basis for why.
But it's a different criminal offense. It's different than unlawful contact or communication.
Correct. It's an entirely separate can of worms, and that's why, Correct, Your Honor. I would offer that, the idea behind unlawful contact, the legislative purpose behind it, the fact that we're dealing with different forms of communication or different ways to get a message to a juvenile are to get them in a scenario where they can be exploited, have, sexual violence perpetrated to them. It's all the things that lead up to that, but on the record, on its face in this case, it just happened, and there wasn't further contact. Or, I would even submit that if during the assaults, my client and Mr. Strunk engaged in further, we'll call it dirty talk, even though that feels wrong to say, if he was saying things during the assault like, I want you to move this way, that way, you know, etc., I would lose. There's just nothing in the record that indicated that.
You're sort of looking a gift horse in the mouth.
Why are you doing that?
You're undermining your own argument. I mean, now you're, well.
Yeah, I guess what you're also saying is Commonwealth versus Velez should be overruled or vacated by this court, correct?
Yes.
Anything else?
All right, I actually think we understand your argument. Are there any other questions for Mr. Bradley?
No, thank you.
Okay, thank you, Mr. Bradley.
Always a pleasure.
Let's hear from Mr. Lysott. Did I say it correctly?
Yes, Your Honor. Thank you very much. Good afternoon, Your Honors, and may it please the Court. My name is Ryan Lysott from the Dauphin County District Attorney's Office, here on behalf of Appellees, the Commonwealth of Pennsylvania. Is there anywhere you would like me to start? Or
yeah, I'd like you to start with this. Tell me, kindly tell me, give me a scenario, counsel, in which this claim could not be brought in conjunction with any sexual assault of a minor charge.
I think and if I'm talking about the same thing you hopefully are, it was the circumstance where it was just the grabbing of the grabbing of the underpants and pulling them down. I think that might be a circumstance where this statute may have some overlap.
We all know it has some overlap. My point is, it entirely overlaps. I need you to give me a scenario, if you can, in which the Commonwealth could not, under this reading by the lower courts, that the Commonwealth couldn't charge this like a lesser included. It rides along with every single sexual assault of a minor charge, does it not?
That would be, yes, listed in that subsection.
Okay, well then haven't you just told us you are, as the DA's office, you're creating a strict liability offense? Because it arises from every single sex assault.
I don't think strict liability would necessarily, not to disagree with Your Honor, be the term here, considering there would need to be.
It would be a per se crime.
Well, you would still need intent.
I guess, what is your position with regard to Justice Brobson's concerns about precondition versus communication? Because Commonwealth versus Velez, in my mind, the court just speculated something and convicted someone for pure speculation, because they made the position of a young child, which is a precondition to the criminal offense, they made it a contact. So, and that's what we have here. So I guess the question, if you share with us that the touching of the underwear or the pajama pants in and of itself is a communication for contact definitions, and it's also a precondition so that he can insert himself in her, then we have insisted that you're asking us to condone making every sexual offense the predicate offense of unlawful contact with the minor, which is in essence per se, or used another way, a strict liability crime. Are you asking us to do that?
No, Your Honor.
Right, share with us what you're asking us.
I do think there are circumstances where there is no manipulation required. Let's say that someone encounters another individual and that they just accomplish the act. There's no touching. And so I don't think there would be any.
How is that humanly possible?
Well, I mean,
unless you know science that I don't.
I meant precipitative touching. No precipitative touching. Just go.
You're assuming a circumstance where someone is unclothed and already in a position where someone could simply come up and engage in a sexual act. But is that honestly? Let's not think about that. Let's think about the worst possible circumstance of a woman walking to her apartment from work, who gets grabbed, beaten, clothes ripped off, and sexually assaulted. Let's look at that circumstance. You're charging not only for the sexual assault, but for unlawful communication and contact. That's your argument. At least, I mean, as much as I can glean from your brief, which I think was a little light, but I mean, that's your argument. Because they manipulated the clothing, or they pulled her into an alley.
Well, and I think that given the expansive definition contained in the statute, I just don't think that that is inappropriate to argue. I think they keep expanding the definition and expanding the definition. When they're here, we have direct or indirect contact or communication. If communication and contact meant the same thing, I don't know how having the disjunctive or would have any effect and be written into the statute.
Well, I can tell you how. Because the expansion, I think, is being done by your office in a completely unnecessary charging decision where you've got the goods on a guy for all these sex assault substantive charges, and yet you throw in this. This is obviously for grooming purposes. If it's not for grooming offenses, then what's the language about a law enforcement officer acting in the performance of duties who has assumed the identity of a minor, et cetera, for the purpose of engaging in it? It's clearly for cases which happen, which need to be prosecuted for inducing. So why do you need to go beyond that and make it a tag-along per se offense in every sex assault case? I don't understand that.
I don't think it extends necessarily to the extent where it has to be grooming. For example, the case where the girl knocks on the door, the defendant who's standing behind it naked doesn't answer, and then she walks in. And that was held to be the communication required for the unlawful contact there. So I think
that was silence as communication. In other words, he was inducing her to enter in by not answering the door and saying, "Hey, I'm in here."
But it's not like a grooming situation where it's like it's to get.
It's not limited to grooming, but grooming is probably the best example.
That's a great example.
Certainly inducing.
Sure.
Inducing is certainly required.
Right. Or like touching them on the shoulder. I mean, that's a communication too. It's like, I mean, so I didn't, obviously intend to upset or anything with my arguments.
I don't think you intended to upset. I think though there's a reason why we took the case, and it's the precedent here is a little bit challenging, and I think the big concern is, which again I'm not sure your brief really tackles it, is this merger question. And you sort of rest your brief just sort of talks about Velez, and you talk about the cases, but you don't specifically address this problem, which is the merger problem, and the idea that as a result of your interpretation of what the Superior Court has done here, every sexual assault has a contact or communication component, and they can be separately charged. That's why we asked you to hear here today.
And we understand the issue. If you want to, wrap up, you're welcome to do that.
Well, yeah, I mean, mostly just addressing any questions hopefully your honors have, but other than that, I mean, my arguments have been set forth. I do completely understand your reading of this, and, I kind of noted that too as I was going through this, so, we just charge based on precedent. The precedent said one thing, so we don't intend to, we just do what the law tells us.
We just do what?
What the law tells us.
Oh, okay. Understood. All right, well, thank you very much.
Thanks,
Joe.
Office of Disciplinary Counsel versus Arcady Grays, representing Mr. Grays, Mr. Josh Byrne, representing DC, Mr. David White.
Good afternoon. In this disciplinary matter, we review the disciplinary board's recommendation to impose a 5-year suspension of the law license of respondent Arcady Rays. According to the board, Rays represented a creditor in bankruptcy proceedings before the Federal Bankruptcy Court of Florida and participated in a sanctions hearing before that court. The bankruptcy court found that Rays and his client demanded monies from the debtor coupled with a threat to disclose certain information to the bankruptcy court, and that these actions violated the Bankruptcy Code's automatic stay provision, and that Rays submitted a photograph to the bankruptcy court that was doctored, and that Rays deliberately omitted an order from the bankruptcy record. Furthermore, the bankruptcy court found that these actions established bad faith on the part of Rays and his client. In the disciplinary proceedings before us, the disciplinary board applied offensive collateral estoppel to use the bankruptcy court's findings against Rays. Rays has asked us to address 3 issues. Number 1, whether the application of offensive collateral estoppel is appropriate. Number 2, whether the disciplinary board improperly precluded Rays from supplementing the record with evidence regarding a disciplinary action in Florida against the Bankruptcy Creditors Council. And number 3, whether the disciplinary board's recommendation to suspend Rays' law license for 5 years is appropriate.
Thank you, Madam Chief Justice. Justices of this honorable court, good afternoon. I was afraid earlier on that we might not get to this until 5 or 6 o'clock tonight, so I'm happy to be here before you now.
You never know.
I am Josh Byrne. I am here on behalf of the respondent petitioner, Arcady Rays. Fundamentally, respondents are not seeking any change in the law, but seek to have this court and the disciplinary board apply well-established principles of collateral estoppel in a limited and considered manner in order to protect the important due process rights which are implicated whenever an attorney's license is at issue. Declining to do so would erode due process for attorneys facing suspension or loss of their license, and would create a situation where attorneys would frequently, if not always, be required to withdraw from representation of clients when faced with motions for sanctions. We do not assert that there is no place for the use of non-mutual offensive collateral estoppel in disciplinary actions, and agree with existing precedent, which creates a very limited but important role for its use. The use of non-mutual offensive collateral estoppel requires the ODC to establish the standard 5 elements for collateral estoppel, as well as the 4 elements that the Supreme Court of the United States has set forth for the use of offensive collateral estoppel. What we urge here is that it is only appropriate in matters where the attorney was a party to the action and therefore did not have an ethical duty to put the client's interests before their own. Where the burden of proof met or exceeded preponderance of the evidence by clear and satisfactory evidence, the standard this court has utilized in disciplinary matters for nearly 100 years, and the court or jury decision or sanction was in and of itself a violation of a rule of professional conduct. All of these factors were true and are true in cases where an attorney was a criminal defendant, which is traditionally where we have used offensive collateral estoppel. They were also true in the Keisweiter matter, which is the main case relied upon by the ODC. None of these things are true in the present matter. Significantly, we urge this court to reject the ODC's attempt to change the burden of proof utilized in attorney disciplinary matters, which is necessary for the application of offensive collateral estoppel in this matter. The ODC urges this court that it should apply a mere preponderance of the evidence standard rather than preponderance of the evidence by clear and satisfactory evidence. Again, the standard that this court has utilized in disciplinary matters for nearly 100 years.
Counsel, what is preponderance? Where do we apply preponderance of the evidence by unclear and unsatisfactory evidence?
Preponderance of the evidence as a plain standard without clear and satisfactory is a standard that is used all of the time in regular civil actions.
But I'm asking, I'm not trying to be cute. No. But you're suggesting preponderance of evidence by satisfactory and clear is different from regular preponderance of the evidence.
I am suggesting
does that mean preponderance of that the other preponderance of evidence is unclear and unsatisfactory?
No, it does not. Okay. But it means any evidence. And that is
even unclear and unsatisfactory evidence.
One would hope not, but certainly even circumstantial evidence. Anything, as trial judges will tell a jury every time we go in front of one of them, anything that tips the scale slightly one way or the other.
But can I follow up? Because this isn't your fault, and it's not your opposing counsel's fault. It's this court's fault. For a long time, it's not the main dispositive thing in this case, but it's an issue in the case. This clear and satisfactory language.
Yes.
I mean, we have preponderance. That's well settled. We have beyond a reasonable doubt, and clear and convincing evidence is pretty well settled. With certainly with 9 with fraud and everything, but clear and satisfactory. While we must apply it here, use it in this case, shouldn't we abandon it prospectively? I mean, because as Justice Brobson's question suggests, by implication, anything that does not meet that standard must be unclear and unsatisfactory, and maybe it's time just to entomb that language and stop perpetuating it forward. Do you have a view on that?
I do have a view on that, and while I would be happy with clear and convincing evidence as a standard, I do think that our court has considered and intentionally utilized clear and satisfactory as a intermediate burden.
Well, we already see that's just one more thing. We have an intermediate burden. It's called clear and convincing.
Yes.
And what this court has done, not you folks,
Understood.
What this court has done for a long time is casually, or I would suggest unthinkingly, pitch this term forward, clear and satisfactory, or at least done so often in these cases. And I don't know what it means, because if it means anything, there must also be a group of cases that are not encapsulated within it. And that liminal space between clear and satisfactory and preponderance of the evidence is highly elusive and undoubtedly subjective. I don't know how we can go forward with a disciplinary system here for lawyers where lawyers are subjected to doubt as to whether this hearing committee or that hearing committee is going to find the case falls into that liminal space, because nobody knows what it is between preponderance and clear and satisfactory.
Your Honor, excuse me, Mr. Justice Webb, my apologies.
No.
I would not object and do not think that there is a impropriety if this court were to decide that clear and convincing evidence is the standard that should be applied in disciplinary actions. Our court has considered that in the past and adopted, and in 1974 in Erie, I think is the closest we get to a really decent discussion about this, looked at Van Camp Seafood, which was a civil forfeiture case. And it said, for forfeiture, not clear and convincing, but a higher degree of proof than mere preponderance, a mere balance of evidence in favor of the government is required. It is necessary in a case like this that the government should establish by clear and satisfactory evidence that the case has been made out. And in Erie, the court said this is a reasonable intermediate standard to utilize because, in quotes, clear and satisfactory evidence is required because of what is at stake. A highly trained professional may lose his ability to earn a livelihood and suffer damage to his professional and personal reputation. And again, that's why the Superior Court adopted that in a medical review case.
But counsel,
yes.
Intermediate step to what? Is that less than clear and convincing? Is it, I mean, why would we create a totally different burden of proof in a situation like this where we have other cases where similar interests are at stake and we use a clear and convincing evidence standard?
Again, Madam Justice Donoghue, I would not argue against utilizing clear and convincing.
Okay, but you just read a string of cases using the other language.
Clear and satisfactory, yes.
I don't know what that is.
And I will tell the justices that yesterday I was presenting over at Rutgers Law School on oral argument and was talking about this case, and the law professor looked at me and said, "Clear and satisfactory?" And it is a real question. What is that? And for my purposes, the import of it is that this is something more than mere money. And so a standard higher than preponderance of the evidence should be utilized.
But the problem with that is it's preponderance of the evidence by clear and we're sort of divorcing clear and satisfactory. See, I think it almost seems to me like it was surplusage, like it was stating an absolute certainty in all cases. We always require clear and satisfactory evidence in every case, whether it's clear and convincing burden of proof or preponderance of the evidence burden of proof. We always expect clear and satisfactory evidence to meet that burden. I think I think it's interesting. I think Justice Weck said it very well that it may be that the disciplinary board, because of us, has given special meaning to that beyond preponderance of the evidence. I like this idea of maybe perhaps moving to a clear and convincing evidence standard from beyond. I mean, that's what we're subject to. We can't be disciplined in the absence of clear and convincing evidence. Why should lawyers be any different?
And I do think, Justice Robson, that there is historical precedent for that. The language, the clear and satisfactory evidence, if we go back that 100 years, seems to me, in the cases that I looked at, and I'm afraid I can't cite them for you verbatim, but they are included in my brief, that was originally in fraud and fraud adjacent cases. And in those cases, for the most part, we have abandoned clear and satisfactory, other than in some fraud-related things that deal with estates and that sort of thing. But we have generally abandoned that language in favor of clear and convincing. And that's what makes the big difference here in Keisweiter. Because in Keisweiter, a court found liable, I was just about to correct myself before Justice Weck did.
Well, your brief has him convicted.
My apologies. I do make that mistake on occasion. He was found liable for fraud, which required clear and convincing evidence. And that is a standard that this court found met or exceeded the burden for disciplinary actions. And if this court were to be clear that going forward, clear and convincing evidence was required, that would make perfect sense to me, because it is a higher standard that has been relatively well defined. And I understand all of the justices questioning about the clear and satisfactory evidence standard, because it is not one that we come across very frequently.
We've just been torturing you with our own problem. It's not a problem you made. But the point of your argument on this issue, though, is regardless, wherever in that weird ephemeral space between preponderance and clear and convincing sits this clear and satisfactory thing, whatever it is, the sanctions hearing in front of Judge Isikoff didn't go there. It was just down here at preponderance.
Absolutely correct, Your Honor. Justice Weck, excuse me again.
You can say, hey, you, or pal, chief, I don't care.
Justice Weck, I would do my absolute best not to be so informal in front of this esteemed body. But you're absolutely correct that the issue here is that to sanction somebody in the bankruptcy court or in the court of common pleas, you don't need anything more than a preponderance of the evidence. And therefore, I hate to say it, but all of us who have been litigators have made some judge mad at some point in time. And that judge can sanction us based on the activities that we engaged in. Part of the issue here is my client was representing a client. And that is the other really big difference between Keisweiter and my case, is that we do not have a similarity between a disciplinary action where my client is only representing himself and his interests. Our rules of professional conduct require an attorney to subliminate their interests to a degree, not completely, but to a degree to their clients. The easiest example of that is in the most common motions where we get sanctions, in a motion to compel. In a motion to compel, if the client doesn't give you the answers that you can provide to somebody, you can be sanctioned for it. Eventually, you can get a serious sanction that would be against the attorney and the client jointly.
Yeah, but there's a big difference between an error of omission and an error of commission. If you don't have the documents and you don't respond, you can be sanctioned. There's a big difference between that, would you agree, and an error where your client says, I want you to do A, B, and C, and you as an attorney know A, B, and C is not supported by the facts of the record. You have an affirmative obligation to candor to the court, or to refrain from doing that, do you not?
At some point you do, when it becomes where it becomes something that would be violative of the rules of professional conduct, yes. But up until that point, the rules of professional conduct requires the attorney to listen to the instructions of the client. That is one of the reasons why I think that Rule 1.4, communication, is so important, because you want the client to be making the decisions regarding the representation as the rules require.
So that line is difficult, and I think all of us, when we're in private practice, probably encountered that line where a client wants you to be aggressive or do something. Is there anything in the record here that your client did this at the direction of, or your client did this at the direction of his client? That I went to this thing because I was told to do it by my client. I filed this because my client told me to do this. This was done. I mean, there's no client blame going on here.
No, absolutely not in this case. I'm just suggesting.
This was the judgment of your client.
This was the judgment of my client. And my client has very explicitly said that he made a terrible mistake in going to meet with the attorney in person in Florida. And whether we agree with Judge Isikoff or not, she determined that there was a threat made, and that was the violation.
Would you have a problem if the D board or the hearing committee simply had accepted the bankruptcy judge's findings and order and considered them as part of the record, so long as they didn't give that preclusive effect?
Absolutely. That is evidence that is part of the record.
I thought there was a hearsay objection.
I had a hearsay objection. There can be a hearsay objection there, but there was a finding by the judge. And when it comes to the point that there is a finding by the judge, I think the ODC can at least rely on that as a fact. But there was not, and one of the things that I believe I heard in Chief Justice Todd's recitation, there was no finding that the photograph was altered for an improper purpose. The judge did, in her statements, in her colloquy, say that she was troubled by it, and there was no finding, or the sanction was not based on a finding that the POS was fraudulent, that the entirety of the sanction was based on the alleged threat. And so my client was unable at the disciplinary hearing to go into the facts regarding the threat. And that's really where we were hamstrung in this case.
Suppose you weren't hamstrung and there was no collateral estoppel ruling. What evidence or testimony would you have introduced at this hearing?
Sure, there's two things. The ODC has suggested that this is harmless error because my client did speak about it. But if we had been able to actually go in and discuss it, there would have been a thorough going through all of the submissions, including the response in opposition to debtor's motion for sanctions, where it talks about the pictures and shows all of the photographs. And one of the things that is clear when you go through the record about the threat is that this was part of a continuation of a whole discussion. And the other thing that happened is I did not become aware, my client did not become aware of Mr. Nerdinsky's disbarment in Florida until after the record had closed, in part because we were told that we could not present evidence on the threat. Again, my client was able to discuss it, but had I prepared to present whether this was actually a threat or not and to question the evidence that Judge Isikoff saw, I believe that I most likely would have found out during that interim period, a very short period, that Mr. Nerdinsky, who Judge Isikoff relied upon, saying that he was more credible than my client, had been disbarred by the Florida court for creating false orders.
You didn't put him on your witness list, though.
I did not put him on my witness list. I did not put him on my witness list. I can only guess, Justice Wecht, at what might have happened. But had I been allowed to present those arguments, I would have looked into Mr. Nerdinsky again and would have determined, I would hope, that he had been disbarred at that point and would have been able to put on evidence regarding that.
But you had at the, I guess that's what it goes back to Justice Wecht's question, which I think is a very good question. Then, if you had all of the record from the bankruptcy court in front of the Office of Disciplinary Counsel.
Yes.
Presuming you had the arguments made by counsel during the proceedings, you had whatever submissions, the briefs that you're pointing to us that you had, they were available there. What was, other than the preclusive collateral estoppel position, what was preventing your client from vigorously arguing why? What additional evidence would you have put forward? I mean, you could have put forward the evidence of the discipline and said, oh, that guy that the trial court, that the bankruptcy court judge said was credible was subsequently. I mean, that's an interesting argument, because were they lying at the hearing or were they lying later? I don't know. But what can this record be used for?
Sure. What I was fundamentally precluded from doing is going through with my client and questioning him with respect to the meeting with Mr. Nerdinsky, because I was precluded from relitigating the question of whether this was a threat or not. If I had not been precluded from relitigating that, I would have questioned my client step by step. Why did you go down to Florida? Why did you choose to meet? What was said during the meeting? What did Mr. Nerdinsky say to you? Why
that's all in the record, isn't it? It's in the. He was able to present all of that to the bankruptcy court judge.
He was able to present that to the bankruptcy judge, but I was not able to question him on that in front of the hearing committee.
He was doing it as the lawyer. He was unrepresented by counsel.
Correct. As well as the fact that, again, I can't say with certainty that I would have learned about Mr. Nerdinsky's position had I been able to question him regarding that, but that's certainly.
Don't we just need to remand it for a new hearing? I mean, what's your basis for saying we should dismiss the matter or remand for non-public discipline? Doesn't it have to go back and get a new hearing?
That would be my alternative request, Justice Wecht. My main suggestion and my belief is that dissenting board member Vance got this right. That if you look at the record in its totality, and I think Justice Brobson is absolutely correct, it's all there. And I hate to suggest, and I'm not going to suggest, that the board didn't look through the entire record, but if you look through the entire record, you will see where this photograph was first presented. It was presented in front of the court in Philadelphia to show a continuation of apartments and fancy cars and watches throughout the entire time that my client was trying to collect on this debt in order to prevent the debtors from asserting that they had no ability to pay. My client was actually successful at that in Philadelphia and was successful at every appellate level in Pennsylvania. And it was only after my client won at every single level in Pennsylvania that these folks filed their bankruptcy in Florida and the trouble ensued. But that photograph was not put in to show a temporal thing, and even in the bankruptcy court, if you read the filings, that photograph is included in several pages that say, in Pennsylvania, we submitted this to establish the continuing wealth of these folks. So, with all due respect to Judge Isikoff, and to the opposing counsel underlying, it's simply wrong that he edited it to show a recency. He edited it to show the watch. Just like in the next photograph, right below it on the submission that he sent in, there's another photograph which is edited. It is edited to take out the person standing next to him. The photograph in question was edited to take out the person sitting next to him. My client didn't know who that person was. Didn't know whether it was a wife, a daughter, a mistress. Did not think it was relevant. Edited it to show the watch. He wanted to show how much bling this guy was flinging around all the time so that he could show the court in Pennsylvania that this was not a destitute person and it's somebody who could pay the debt that the court in Pennsylvania found was owed.
Counsel, maybe this is a question better asked to your opposing counsel, but what exactly was it, factually or by issue, that ODC was attempting to use for purposes of offensive collateral estoppel? Just list it for me. I mean, because
sure,
you're talking about facts that were adjudicated, and the predicate issue here was that the automatic stay was violated.
Correct. And that's...
Period.
Period. Yes. I would completely agree with you, Justice Donahue.
But everything else that we're talking about here has to do with the nitty-gritty of evidence that was submitted. So if you could answer my question, what exactly were the issues or facts that ODC attempted to use offensive collateral estoppel?
Sure. The biggest one, for purposes of the inability to present the case, was that it was a threat. So
what was the threat?
During the meeting with opposing counsel, my client said, I have all this information about all of the companies that your clients are involved in. You didn't list that on your bankruptcy schedules, and I'm going to have to hand that over to the trustee.
Okay.
We can avoid that if we settle this case based on the numbers we've been talking about before this. Judge Isikoff said, yes, there is an exception for continuing settlement negotiations, but found, based on Mr. Nerdinsky's testimony, and she said so in her opinion, based on finding Mr. Nerdinsky's testimony.
I understand that. So the threat.
That's the biggest thing for me. But very importantly, I was also collaterally estopped from asserting that the photograph was edited. And I don't know how much of a difference it made, because I was able to say why it was edited, I think. But I do believe that the fact that I was collaterally estopped from stating that it was edited may have had some issue with the 3.4 violation, and that's a really big issue. And so there's the 3.4 violation, the obstruction or destruction of evidence. And I have concern that because there was this collateral estoppel order saying that you may not present evidence to say that the photograph was not edited, that led more or less directly to the 3.4 violation. And equally, that's part of the 3.3A and the 3.A1 and the 3.3A4 violations.
All right. There are a lot of particulars that we're going to look at in this matter. Is there anything you'd like to say in conclusion?
Chief Justice Todd, I think the most important thing in terms of what happened in the underlying case and what sort of discipline my client deserves to have implicated requires a full reading of the record. And I have no doubt that this court has a capability of combing through the record and seeing, as dissenting member Vance saw, that when you look at the totality of the record and not just at Judge Isikoff's decision and what she said in statements during the court, then you see what my client did probably not best practices by any means, but it's hardly something that should require this court to take his license for 5 years. The only thing that this court can do that is less than a disbarment, that is a huge sanction. And I do not believe, I can argue the collateral estoppel issue all day and would be happy to, but fundamentally at the end of the day, if each and every one of you looks at that record, I think you would be hard-pressed to believe that my client deserves to have his license taken away for 5 years.
We understand the gravity of the situation, and we appreciate your argument, Mr. Byrne. Let's hear from the Office of Disciplinary Counsel.
Thank you, Madam Chief Justice. May it please the Court, my name is Daniel White. I represent the Office of Disciplinary Counsel in this matter. This case presents precisely the circumstances for which the doctrine of collateral estoppel exists. When confronted in these disciplinary proceedings with allegations identical to those he had previously litigated before the United States Bankruptcy Court for the Southern District of Florida, Mr. Ray's asserted defenses identical to those he had previously asserted unsuccessfully before the Bankruptcy Court. Indeed, Mr. Ray's himself appears to have acknowledged the appropriateness of applying collateral estoppel in this matter in his own verified statement of position, which was admitted as ODC Exhibit 35 at the disciplinary hearing. Mr. Ray's indicates therein that the Bankruptcy Court's findings, and this is a direct quote, would be conclusive in a litigation context. That's page 34 of ODC Exhibit 35. The hearing committee and the disciplinary board agreed and concluded that the Bankruptcy Court proceedings satisfied each of the 5 elements necessary to invoke collateral estoppel, and that each of the 4 fairness factors favor collateral estoppel's application.
Clear and satisfactory mean?
Couple things. I did take Justice Brobson's remark that it may be surplusage. It appears that this court may be leaning that way based on every disciplinary opinion that's issued since 2012. However, to the extent that the court wants to preserve the clear and satisfactory language, the Office of Disciplinary Counsel would submit that the correct interpretation was that advanced by the Commonwealth Court in the matter of Starr versus State Board of Medicine, that clear and satisfactory, when used in conjunction with preponderance of the evidence, describes the quality of the evidence, not its quantum.
So basically it doesn't mean anything. It's just extra verbiage.
Correct.
Here's the problem I have, if I could just supplement. The problem I'm having at this point is that, speaking for myself, I can't know that the relevant decision makers here weren't inferring that that's a level of proof of somewhere above, I don't know where, but somewhere above preponderance of the evidence. And if that's the case, I don't see how you get issue preclusion.
Well, what you can infer from the disciplinary board's report, they indicated that because damages were awarded in the bankruptcy court proceedings for emotional distress damages, which requires Mr. Lyabarski to clearly establish the emotional harm, they said by doing so, Mr. Lyabarski satisfied a burden that exceeds the burden in the disciplinary proceedings. So taking that remark in the disciplinary board report, it would indicate that the board recognized that clearly establishing something in a prior proceeding is more than the Office of Disciplinary Counsel is required in a disciplinary proceeding.
Counsel, do you agree that your burden of proof is higher than a mere preponderance of the evidence?
No, the Office of Disciplinary Counsel's position is that its burden of proof in a disciplinary proceeding is and has always been a mere preponderance of the evidence. And that's reflected in again, this court's jurisprudence in every disciplinary opinions issued since 2012.
Going forward, shouldn't it be something higher, given that this is reputation and livelihood and not just mere money?
No, a couple reasons. First of all, we cited several other licensing proceedings, physicians, nurses, barbers, where it's always a preponderance of the evidence, and Mr. Reyes hasn't cited any other licensing proceedings where it is higher. So I would submit to the court what's different about lawyers as opposed to physicians. The other point, and we made this point in our brief, is that this court knows how to impose a heightened burden. It did so in the Rules of Disciplinary Enforcement in two places. Rule of Disciplinary Enforcement 218C3 and 301H regarding matters involving reinstatement from disability and discipline. And both of those rules, this court imposed a clear and convincing burden on the reinstatement petitioner. But Rule of Disciplinary Enforcement 208, which governs disciplinary proceedings, does not set forth a burden of proof.
Why isn't that why isn't that a little incongruous? I mean, why?
Totally unfair.
Why? You know, first of all, we are subject to a clear and convincing standard for purposes of judicial discipline.
Sure.
And it seems odd that when your livelihood is being taken away, even if temporarily, the person attempting, the body attempt, well, us basically, we only have to do preponderance of the evidence. But if you want to come back, you have to show clear and convincing. Give me your best argument as to why we should just not, since we're dealing with a professional, a job that is under our jurisdiction, medical licensing and things like that are not under our jurisdiction, obviously. We shouldn't say it's clear and convincing evidence, period, and end this ambiguity and debate of comparing, for collateral estoppel purposes, particularly in civil matters, that debate. Clear and convincing.
Well, because this court has never said that.
I understand that. That's not a great argument. But give me your best argument as to why preponderance of the evidence should be the continuing standard as opposed to clear and convincing evidence.
Because it's required by the rules promulgated by this court and by the disciplinary board.
And he's asking you prospectively. I mean, we are sort of prisoners of the mess we've made to date, but for this case. But going forward, this would be an opportunity, and since you're speaking for ODC, we thought maybe you have a position on what it should be going forward.
Sorry, let me just clarify. You're asking if this court would promulgate a provision of the Rules of Disciplinary Enforcement imposing a heightened burden in disciplinary proceedings as they did with reinstatement proceedings?
Yeah, change the burden.
Sure. I mean, that would be a policy argument that this court certainly has the authority.
Let me stop you for a minute before we go on. Is there an affirmative statement anywhere as to what the burden of proof is for ODC in disciplinary proceedings?
So there's a provision in disciplinary board rules, 89.92A. All it says is that the Office of Disciplinary Counsel has the burden of proof in a disciplinary proceeding.
Okay, so we aren't actually changing any rule.
Well,
there is no rule.
Well, except there are some rules that you pointed out that do specifically reference a heightened burden.
As to the respondent's burden of proof.
Which might suggest that they suggest that because everything else is a lower burden. I don't know.
Sure, and that's certainly ODC's argument here, that if this court wanted to impose a heightened burden, it knows how to do so. It could have done so. It did not in Rule Discipline Enforcement 208. And just to follow up on Justice Donahue, the section 89.92A, which says ODC has the burden of proof in a disciplinary proceeding. This court explained in the Sadling-Hosiery case that when the phrase burden of proof is unqualified by any other language, it means by the fair preponderance of the evidence.
Let me ask you, then, and again, it's not your fault, it's not your opposing, it's our fault, I keep repeating that, but we've carried forward this like mantra about by clear and satisfactory evidence. So, presumably it ought to mean something. In fact, we probably just unthinkingly kept canning it forward. But given that we've done this, given that we've made this mess, why don't we have to, in disposing of this case, why don't we have to recognize the real possibility that the committee or the board might have given an extra little bit of it, like a little bit of a extra oomph, to that clear and satisfactory on the rationale that it's got to mean something.
Well, respectfully, I don't believe this court has been canning this forward. This court has not used that language since 2006. The board sometimes uses that language in their reports, but this court, and again, every single opinion that's issued in a disciplinary case since 2012 simply said it's ODC's burden to establish attorney misconduct by preponderance of the evidence, period. Doesn't mention anything about clear and satisfactory. And I think that may be an acknowledgement almost of what Justice Brobson and Justice Weck were getting at earlier, that this language might not actually mean a whole lot in the first place.
All right, do you want to wrap up, sir?
Sure. I'll just briefly summarize why a 5-year suspension is appropriate in this case. I believe that the court can impose the 5-year suspension recommended by the disciplinary board in this matter without even getting to what the hearing committee characterized as extortionary misconduct. And that's because this court has told us over and over and over again how important honesty is to the practice of law, particularly when dishonesty is perpetrated before a court. And this case not only includes multiple instances of dishonesty before a tribunal, but the hearing committee and disciplinary board also agreed that in defending against those allegations in these disciplinary proceedings, Mr. Reyes again resorted to dishonesty and provided demonstrably false testimony.
Counsel, did ODC take into account that the bankruptcy judge was asked to refer this case to the Florida disciplinary body and it refused to do so?
I'm sorry, can you repeat that?
In prosecuting this case, did ODC take into account that the bankruptcy judge was asked to refer this attorney to the Florida disciplinary body and the bankruptcy court refused to do so?
No, that did not inform ODC's decisions in this case, Justice Donegal.
And what you were doing, what ODC did here is you applied the Florida rules of professional conduct.
Correct, based on the choice of law provision in Rule of Professional Conduct 8.5.
Okay, thank you.
Thank you.
All right, thank you very much. Mr. Minner, would you call the next case? And we have some recusals on this case.